And we might want to show participants if it, I mean, so that it gets a separate screen. It's admit you probably. Owner. You be the owner. There's another one. Okay, so it's coming. Here we go. So we have admit all maybe. Hi, we're just getting set up here. Your video's on.
Good morning, everyone. Can you hear me? Is anybody connected? Hello.
Oh.
No.
Okay, so we're getting set up here.
Why are you on screen?
Because I'm attending.
It looks ridiculous.
Okay, I'll stop video.
All I can see is you. Can you see my screen?
Say again louder. No. I see Rex Crandell window and I see Chan.
Stop talking about
I- So we'll be getting started here in a moment. Started. I did want to do one thing. If you could click this out, it would give us half a more inch.
How?
Just click in it. I don't know.
It doesn't leave.
Okay, I had got it. Is the screen set up well for you?
Fine.
Okay.
I'll figure it out.
Mic's on, audio's on.
Let's see.
Can I share the screen with you from the beginning or not? Go to my other desk.
I don't care what you.
It's up to you.
I'm just gonna glance in.
Where is, oh, there it is. Our picture.
Let's see if I can get any of these. I don't see rooms. I don't see them here. There's just a few that are. Okay.
From the
You
lower.
won't be able to stand next to me like this.
Okay.
So you probably, so you could see the screen and be able to tell me will be better in that area.
Okay. Sure. You can do that.
I don't know. I think I somehow got onto somebody's screen. You see how it says?
Oh, is it?
Good morning, everybody.
And then what you do is you can just see the little thing down here. You just press it and then press when you want to get back
I
on.
want to be on it, so I have to take the class.
Okay, you still want to print something?
No, I just want to be on the class.
Okay. Alright.
Click
So
that
we
box
can-
up there, so we'll make it bigger.
Okay.
All right.
And then do you need anything else or?
No.
Alright.
Is everybody ready?
Yes.
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 Hi, everyone. Good morning. My name is Tamara, and I'm going to be the one who is starting the class today. I've been doing this for quite some time, so if there's anything I roll through too fast, please let me know. I'm going to leave everybody who wishes to keep their mic off just to introduce themselves at the beginning, but then I will be muting all of the, I will ask you to mute your own mic so that I don't have any background noise. But if you wish to comment, if I ask a question and you wish to comment, then please just unmute your mic. Okay, so some of the participants here, I'll explain. Some of the participants here may be from CALDA, who they are already LDAs, but they'd like to learn the workshop or the accounting workshop. And then others who are here come from the courts, and they are usually doing like a probate or a conservatorship or a guardianship pro per, which means they are handling it on their own. So they're learning the accounting class just so that they can turn in accounting. So those who are here that are not with CalDO or an organization, but they're here for a guardianship, a conservatorship, or something on their own, if they would like to introduce themselves and just say briefly your situation, or are you in a conservatorship, a guardianship, or what you would like to learn from this class today. And I'll let whoever wishes to start first to go ahead and start first.
I'll go first. My name's Colette Bird, and I'm here because I'm taking conservatorship of my mom. And I don't have no idea what I'm doing, quite honestly.
Don't worry, don't worry. It's going to be a little bit much, but you'll feel a lot more comfortable after today's class.
I hope so.
So welcome. Go ahead. Who's next?
Hi, I'm Ian Fernsler. I'm with Smart Probate. We do probates, but we don't do accountings. And so I'm learning more about accountings to see if it's something that as an LDA I can reasonably and safely do.
Perfect. Good. Okay, who wants to talk next? Oh, everybody's being shy today. Okay, I'm going to go ahead and move on then because I want to get this started. It will last the full length of time. So, and we may run over a tiny bit, but we'll try not to. So if everyone could do me a favor and mute their mic so that I can get started, and then please feel free to unmute your mic at any time when you just have a question, or you need to ask me something, or you wish me to back up or start over, or anything like that. Just unmute your mic. And there's also a feature on Zoom for those who are familiar or unfamiliar, where you can do a chat with us. And typically Rex and I are doing this accounting, so he will follow the chat while I talk, and then while he's doing his part, he will I will be in the other room following the chat and trying to answer questions for you, which are kind of typically offline. So I'm going to go ahead and get started. You should be able to see my screen, and what you should see here is the accounting workshop, a flyer that we have. It's posted at the law library. It's on the Contra Costa Superior Court's website. We do offer Zoom typically once every month on the third Thursday, but that will not take place during the month of March and April, only because we also do tax preparation. And if you can only imagine, that's a pretty busy time. So we have, we will skip March and April, and we will go back to May. Please feel free. This is a free class. We volunteer to do this for the courts. It started with Judge Sugiyama, who is was the probate judge in Contra Costa County. He is now retired, and he, I believe, is a mediator. So he started this, and the purpose for the class was there were many people who didn't understand accounting, knew they had to turn it in, but they were so confused. And so we volunteered to teach this class and help. There are a variety of ways, especially when we get to the accounting part, that the accounting can be done. So if you're currently already doing an accounting and the one you've seen or you've seen in the past looks a tiny bit different, like I said, there are different versions out there. We are typically for this class going to use the court forms. And then there's also like Excel forms. There's a few other forms, but at least this is going to give an overview of the information you'll need ahead of time, or what you'll need to gather and keep for your accounting. So again, you are free to take this class as many times as you want. If you need to take it every single month until you produce your first accounting, you are free to do so. But I will state, we just repeat the information. So it's not like taking the class next month is going to give you any more information than you will learn today. It will be an exact repeat of today's class. So again, if you wish to sign up again, you can do so at the Contra Costa County Public Library. You can do so a few days ahead of time so that we can send you the materials if you don't have them. You can also call them to put your name on the list. Typically it is, you would contact them and you will speak to Carrie Ruan, who runs the Contra Costa County Law Library. Okay, so most of the information that we will be given today can be found in what's called the Handbook for Conservators. Sorry, when I hear a beeping noise, I'm just allowing people in who are joining a little bit late. Anyway, so the Handbook for Conservators, this can be found online, this can be purchased. It does it is an older version, but nothing has changed. So you are free to.
Excuse me, where can you buy this at?
It could be found online. I'm sure if you just did a search, I'm not sure specifically where it can be found at, but you can, here is a link of where the handbook is.
Right, and it's like 300 pages.
Yes, you're correct. It is. It's very extensive.
Okay.
So that's up to you, whether you just keep it on your computer and use it as a PDF later, or if you wanted to print it. If I printed it myself, I would do 2 sides, so you're down to only 150 real pages back in sides, but you're free to do that or just reference it at any time. It's just a reference material.
Thank you.
You're welcome. So I'm gonna go ahead and move on. What you will start with, there are a few things that I must explain is once you are appointed or receive your letters, and letters are what give you the direction by the court or state that you're officially a conservator or a guardian or a administrator or an executor, or you will get what's called letters from the court. And typically you have 90 days from the date you receive those letters or from your appointment to do what's called an inventory and appraisal. And I'll get into a little bit later what that is, basically in details how you would report that. Basically, you have 2 categories. You have your cash assets, which is what it is, strictly cash, and then you have your non-cash assets. And we will go through what is the difference between the two. But I will tell you that when your inventory and appraisal is technically due in 90 days, I would say don't sit on it. I have seen in many cases with the prior judge that if you don't do an inventory and appraisal and follow the steps, at least as best as you can be removed from your guardianship, your conservatorship, or something like that. The court wants to make sure they know everything about what's going on and that you're following the guidelines. And so do potential beneficiaries, heirs, or friends and family who just wish to know if there's a conservatorship. So make sure, and this inventory and appraisal in a lot of cases has to go to what's called a probate referee, which we'll get into that. How do you get one, or how do you know if you have one, things like that later as we complete the form. But the probate referee also needs to have at least 4 or 5 weeks to complete this. So remember, if you're 90 days, if you wait up until the last week and think you're going to throw this to a probate referee and say, hey, I need this back next week, it's not going to happen, hun. So start your inventory and appraisal right away. If you haven't done it and your 90 days are close or your 90 days are up, do not panic. Just try and try and try to do it as soon as possible. And so we are going to go through at the start of this how do I complete a inventory and appraisal. And you can go through this material I've glossed over at your convenience. That's completely up to you. But I'm going to start with what is the inventory and appraisal. When I reference form numbers, or you need somebody else reference, like the court, or somebody references a form number, this is the number they're referencing right here. The DE means decedent's estate, so that's more with a probate. And then you have your guardianship conservatorship. And so it's either the DE 160, they call it, or the GC 040. Okay, so it is when you receive this form, it will be a blank form. So again, this is only an example for you to follow. A few things will be different when you complete it, but we are going to go through this entire form as if it is blank and you are completing it on your own. Okay, so I'm going to get started. The first thing that you're going to do, in this case, we have an attorney who's completing this form. In most cases, for most of you, there is no attorney. You will be completing this on your own. So we're going to start with the first line item would be your name. Of course, you wouldn't have a state bar number because you're not an attorney. So you would just complete your name. Then we would skip this line item and you're going to put your home address or your business address or whatever address you're using for the courts, and then the city, state, and zip. Under telephone number, you will put your phone number so the courts can contact you if they have a question about this form. The fax number is optional. If you don't have a fax, leaving this blank is perfectly fine. If you do have one, a lot of times if they want to put a note on the case or on this form, or they want to ask for fees because you didn't pay the right fees, or they'll state something needs to be changed on this form, they may fax the form back to you and indicate what change needs to be made in that case. Or usually the probate examiners who are at the courthouse, who are basically a whole lot more than a secretary for the judge, but they are the ones who review all these forms ahead of time before it gets in front of the judge and indicate if there's something missing, wrong, or needed on the form, so that when you do go to court or your case is heard, the judge already knows that somebody else has gone through this and what's needed or what needs to be finished or what you've completed that they've said needs to be changed, revised. Okay, so an email address is also a good thing. A lot of times with an email address, I can get the, okay, so when you turn in documents and you get a court case, it depends on the court actually themselves, but about between a week and 2 days before, the examiners will send what's called a tentative ruling. And the tentative ruling is basically the secretary telling the judge, do I have everything? Is it ready to go? Is there anything missing? And typically, if you get a tentative ruling ahead of time, like a week ahead, you have a little bit of time to make the corrections that the examiners have indicated need corrections on. And then you turn it in before the hearing, and then they just cross things off the list. So a lot of times they'll email the tentative rulings to you ahead of time. You would almost stop everything you're doing, try and correct what they want corrected. Otherwise, if you don't correct what they're asking for, more than likely the morning of your case or during the time of your case hearing, the judge will just have to put you off to another court date until you correct the problems that the examiners have indicated are missing or need revision. So the email address, putting one here is a very good idea because typically they'll email those tentative rulings to you. If they put it in the mail, you'll never get in time. And they won't call. I've never had them call you and tell you what's missing or what needs to be corrected. So an email address is good, even though it states it is optional. Okay, so we're going to move down to attorney for. In this case, this is going to be you. So you're not an attorney for. You're going to put your name, and you're either going to put you're a conservator, a guardian, what is your title? An executor, and a special administrator, an administrator, a trustee. And your title could be whatever is given to you with your letter. So you would put your name, and for this instance, we're going to just use conservator. So down here, the Superior Court of California, you would put whatever county. I'm going to use the example for all of today that this is going to be Contra Costa County, which is the county I'm in and the county I typically run cases for, although I also do Alameda, San Francisco, and the local Bay Area counties here. So you would put, or in most cases, or my case, we would put County of Contra Costa. So that's in Martinez. And their address, I would put 725 Court Street. And theirs is long, Department 14, room 212. Their mailing address is P.O. Box 911. I don't know how 911 got to be with the courts, but I think it's kind of cool. Their branch name, typically I leave the branch name off, but the branch name for them, I think will depend on there's three courthouses in Martinez, so it would be whatever courthouse your case is heard in. Okay, moving down, the estate of, you're going to put who are you giving care to, or who are you responsible for, or what estate are you responsible for. So in this case, we're taking care of Jeannie Lowry, and she's the conservatee. But it could be Jeannie Lowry, later on she's the decedent. Or if you're doing a guardianship, it would be Jeannie Lowry and they are a minor. So these boxes indicate what your kind of title is. They should match. For the inventory and appraisal, there are several different ways you can complete this. If it's something that, say for instance, you know it's due in 90 days, but you just haven't had the opportunity to find out, say the person you're doing a conservator, you're the conservator. Say the person, the conservatee, has a bunch of properties in other states or has just so much that you didn't really have a whole lot of time within the 90 days to gather all of the assets. If that is the case, I would have marked this a partial and turned in what I could, but also indicated I am still looking for other assets that are known to me, but I just haven't been able to put my hands on what they are yet. It could be a corrected one. So say, for instance, you turned in one already and you valued, for instance, or you valued, let's say, a stock certificate or an annuity at $1 million, and it really wasn't that. You just wrote the number wrong or you did something wrong. You could mark this corrected. Then we have a final, which means if you completed a partial ahead of time and then you turn around and you correct it, instead of marking it corrected, if it's really a final, you would mark a final. But most of the time you will have this box marked final. It's not a whole lot of time you want to do a partial or a supplemental, or there could be a reappraisal if the there could be a reappraisal on this, but that's not typical either. And very seldom you'll see the property tax certificate. Okay, on the right side here, you will put what your case number is so that they can match this form to your case and make sure it gets into the right file at the court. And then down here, this is a very important date. Either the date of death of the decedent or the appointment of the guardian or conservator. So again, this is the date of appointment typically. So it tells the courts what day is this inventory and appraisal starting. So I'm going to go down to line 1 now because this is the one that we will complete. And this is
Bây giờ bên máy in nó có ra giấy tờ không Thanh?
I'm not sure if that was a question or somebody was just talking. Those two people they mute their mic for me so we make sure we don't have any background noise. Anyway, okay, I'm gonna go on. There's the total appraisal by the representative, the guardian, the conservator, and it is going to be attachment number 1. So I'm gonna flip through a few screens because I'm gonna move to that attachment number 1. And I think it's here, yes. So what this is again, this will be a blank form. At the top, you'll just want to repeat your header that you have here. So it'll be the name of the conservatee. I'm gonna go back, sorry, that's the name you'll put up here, and then you'll put the same case number. Now again, your inventory and appraisal will be blank, right? This is a lot of information on here, but yours necessarily, it could be 1 line. I've seen a lot of times where it's blank because there's absolutely no cash anywhere. Again, attachment number 1 is going to be cash only. And again, it really means just cash that can be spent. It doesn't mean like stocks or other things that you can turn into cash. It just means only cash.
I have a question.
Yes, son.
So let's say you have an account at Charles Schwab and you have $125,000 liquid cash. Is that still considered cash even though it's handled by Charles Schwab?
That's going to be on the next attachment, and
okay.
I'll show you that in just a few minutes.
Okay.
So we are talking cash. Cash. So what is your responsibility and why do you have to put this and where does this all come from? And this is probably a bit overwhelming. What the purpose of this actual form is in this inventory and appraisal is the court wants to know. So say for instance, I get my letters, right? As soon as I get my letters, typically it won't happen like this, but I'm supposed to go, great, now I have the keys. I'm gonna walk into the conservative's house and I'm gonna see what I have. Like, what do I have? If they aren't a relative, a family member, then you may not know a whole lot. If they are a family member, like your mom, your dad, brothers, sisters, aunts and uncles, something like that, you're gonna know a little bit about them. And again, this could be a party, say for instance, which has happened because I have a few cases where the court assigns me to a person and then I know nothing about them. So I need to go in. The first thing I'm going to do is kind of look through mail or ask if there's somebody else there, some questions about what am I going to find? What do I have? So again, what you're doing is reporting to the court. The very day the court holds you responsible for this person, what are you responsible for? This form is reporting to the court, what am I responsible for? Okay, so what an example, and again, I have many examples here. You may have one line item. You may have 0 line items. You may have as many line items as I have. Make sure you just report everything that you see or find. So, and we'll go through examples, so that'll be easy for you. So in the first case, and if I use, like, for instance, my dad, who is an older man, he's going to need to be conserved at some point, not yet, but he's 85 and he's getting there. My dad has cash, always has cash in his wallet. Most older people, they always have cash of some kind. So what does that mean? Do I go through their purse and look at stuff? Yes, you are responsible for reporting this to the court. So don't make it seem like, oh my God, you're invading their privacy by going through their wallet to see if they have cash on them. You must indicate it's your job, it's your duty, it's your responsibility to report to the court what you have, what you find. So in this case, cash found in, you don't need to put in their wallet, in their purse, in underneath the mattress, in a closet, in a jar, nothing like that. If you find cash. Here we've indicated what was the address of the conservatee that I found the cash at. So in this case, you found $250 of cash on them. Again, if you're talking an older person like my dad has that much, you know, even though it seems for the younger generation who only use credit cards now or cards, nobody has cash on them, right? Or very seldom. I never do. But for them, $250 is nothing to have cash sitting at home somewhere. Okay. Line number 2, I would put the balance in the checking account. So let's be careful about this, or let's start off with this. There's quite a few things I want to explain when you indicate this. One, you would need to hopefully find bank statements somewhere and get to the last bank statement you have. Okay, in this case, it's a checking account. And notice that I only have a few numbers here. I will tell you that this form and everything you file with this form, because you will be filing original bank statements from the day you're appointed for a whole year, original. I'll tell you one more time, original. It can't be printed copies off the internet. It can't be anything like that. So if you get appointed as a conservator, it is your responsibility that day you get appointed to go to the bank, show them your letters and state, I need original bank statements mailed to me. I cannot do online, even if that was the Conservatives' choice. It needs to be changed. I must have original copies sent to me because they're going to be turned into the court. But another thing I want to make sure you do is please always protect your conservatee. And protect them, what I mean is, do not ever on your inventory and appraisal list the full account number, because as you can tell, if I listed the full account number, the bank name, the address of the bank, the city of the bank, well, Jesus, I might as well add their social security number and let anybody and everybody just walk away with what they have, right? So be a little bit protective, and what I always do is I myself only include the last 4 digits of the account number. Trust me, the courts aren't interested in the exact account number because they're going to go to the bank and see if what you're saying is true. But what they will glance at is to see if the last 4 digits or some type of combination of that matches your bank statements you turned in, so that they can tell, okay, they can do a matching. What I also do, and that will come later in our example, is when the bank statements are turned in, I always do what's called a redaction, those are the words they use. When you redact something, basically I take a permanent black marker and I will mark out of every single bank statement everything but the last 4 digits on that bank statement, because this is public records. What I mean by public record is you can turn this in and I can know nothing about Jeannie Lowry, but I just want to be nosy for the day, or I'm bored, or I have nothing else to do. So I can go to the courthouse and I can order the file for Jeannie Lowry. All I have to do is provide her name, provide the case number, and state I want to see this file. I can go through this file and, oh, wow, you're going to give me bank statements with names and where they shop and what they buy and everything else. That's great. That's a whole lot of information you may not want other people to have. So again, you are not in trouble, or nothing happens when you redact most of the account number and only list the last 4 digits. The other thing, I typically will go through the bank statement, and if I notice, like, which they really don't do this much anymore, but on the bank statement, it'll say paid credit card for Chase, and it used to give almost the full account number on the bank statement. So I would, again, redact only account numbers. Now, that doesn't mean you can come and say, oh, I accidentally charged something on the Conservatives credit card that was my personal item. I'm going to redact that whole line item and the amount so nobody sees it and can tell. That cannot be done. No, 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 no. When I say redact, you're only redacting the first part of it, and the judge knows that you're only protecting their information by doing a few digits, but you can never redact amounts or names of where it went or things like that. You can only be important things like account numbers. So don't redact anything else. You can, though, if you're worried, although they can find it other ways, like on the bank statement where it has the address of where they're mailing the bank statement. If you wanted to, you could do that part because it's really not necessary to have that address, but just be careful about how much information you're redacting out. But again, protect your conservatee. Okay, so we're going to continue on. So in this case, I'm listing, I found a bank statement at the bank. Here's the other important part. Most of the time you're going to find a bank statement, and that bank statement is going to be for the prior month, right? So we're in January right now. Bank statements haven't come out for January if you end at the end of the month. So I go in the house and I find one that ends December 30th. And I'm going to do just a quick question to see who's following along and listening. So I was appointed on January 5th of this year. I find a bank statement that's dated December 30th of 2020, and the balance in the account is $5,000, exactly to the penny. What would I list right here? Who wants to answer?
Hi, December 30,
No, honey.
2020?
Okay,
Oh,
so it was a trick question, but believe it or
Mhm.
not. Okay, so again, keep in mind what I said. I wasn't appointed until January 5th of 2021. The statement I have is dated December 30th, 2020. Don't you think that any other transactions would have occurred between December 30th and January 5th that I got appointed? More than likely, yes.
mhm.
So you're not responsible for anything that happened between December 30th, that last bank statement, and January 5th when you got appointed. You're only responsible the day you were appointed. So 9 times out of 10, you're going to have to go to the bank or call the bank and say, what was the balance on January 5th, 2021? And that's the number you'll report here. Do not use a bank statement, because again, if something happened from the end of that bank statement till the day you were appointed, and it was fraud or anything else, if you write the number that was on the 1230 bank statement, you're responsible for that cash if it ended up missing, fraudulent, or anything like that. In between that time, you weren't even responsible for it. So you're putting yourself in a little bit of possible danger by using the bank statement for the prior month. So again, it's very important. The day you are appointed is the balance you'll ask the bank what was in the account that day. And that's the value you would put right here.
Understood. Thank you.
Mm-hmm. Okay, so I'm going to move on, and it's going to be the same example. So I had a checking account up here, and I have a savings account down here now. You see the digits are one off. I'm still putting where is the account located. And again, when I'm listing my balances, I will not list the balance on the last bank statement I have. That bank statement only helps me know what the account number is. I would call the bank, go to the bank. I don't think you can call because I don't think they'd tell you over the phone. But I would take my letters issued by the court. I'd take my bank statement and I'd say, one, I need to know how much was in the account the day on this specific day, and ask them to give you a printout or something showing what those balances are. And usually they'll give you the, little white piece of paper that says what the balance was that day. Okay, so in this case, you may not, again, let's say you have a checking, but you don't have a savings. That does not mean that you would put this information here and put 0. If you really don't have a savings account, leave it blank. Don't even put savings, don't put nothing on there. You would maybe just have 2 lines. Okay? So these are only examples of things that you can use on this form, not stating you must have them on the form. Okay. So in our case, we have a CD, or a certificate of deposit. I can state more than likely that this is only part of the account number, although they're using quite a few more numbers. Where did the CD come from, and what was the name? In this case, it's Jeannie Lowry, who is your conservatee, and more than likely her husband, who's deceased, but they were joint tenants, or they had the certificates as joint tenants. So you would indicate that. Now that's a lot of information. You're going, how in the holy heck would I know that, right? That's typically most people's question. Like, how would I know that? That's something you need to go find out and make sure you have indicated that you called where you found out they had a CD, they told you they had a CD, whatever the case may be. You need to call and get information. And again, this value, what date or what value are you going to use? You're only going to use the value on the day you were appointed, no other day. Not the day after, not 2 weeks after, not 90 days when you're turning it in. This must be your balance on the day you received your letters. And it will be verified. So if you say, I'm not going to call them, I'm just going to guess a number, this got to be pretty close, and it doesn't match later, they're going to ask you to make a correction, which means you've got to probably pay another probate referee because this whole entire form has to be redone. And again, it would be a corrected one. So let's go back over here. You did it wrong. You would have to do a new corrected one. It'll be time, expense, just something you really don't want to do. Okay, going back. So we have a savings account. This is the balance. We went through the CD. Now, also in the mail, because there was mail on the dining room table. And this is more or less, this example has a lot to do with, let's say, back in the day. Because a lot of times now, and the only reason why I say that, a lot of times now everything's direct deposited. It's very seldom that pensions or Social Security or anything else are actually issuing a check, right? It's just not really happening anymore. They're all into this direct deposit, saved paper, things like that. So you may not find many uncashed checks like 10 years ago. You would find tons of them. In fact, I've got a probate case that I'm running right now that we found 10 uncashed checks that go back to 1999. Now, in that case, they've now been escheated to the state. And so I'm going to have to go to the state of California and try and figure out how I'm going to get those funds, because even though they're backdated that long ago, and it was prior to me becoming the administrator. So I'm kind of not responsible for it, but I am, because they're uncashed, meaning it is now my job to go hunt them down and try and get them. If you've ever tried to get funds that have already been escheated to any state, in fact, I had 2 of the checks are escheated to in the state of Hawaii. So I have to figure out how I'm going to contact the state of Hawaii and get them to release those funds to me. It's really a headache, but you must do it. So again, I would, on mine, would list uncashed checks from a teacher's pension. What are they dated? They're payable to the conservatee. And in my case, the hard part I had, which I had to go back through even this long, like, say for instance, I just got it now. They're dated 1999. There's no way I'm going to be able to pull bank statements or figure out if they're cashed. First, you've got to figure out, were they cashed? But if you think back in 1999, we didn't have what we have now, which are mobile deposits that you can now take a picture of the check and do an automatic deposit to your checking account. That's going to be really hard later on for people to figure out if that check has been cashed or not. But back in 1999, which is the date of my checks, they didn't have that. So I know that by looking at the back of the check, because I have a few, by looking at the back of the check, if it isn't signed. And then the other thing would be, if you deposited the check, especially from 1999, she wouldn't have a copy of the check, right? A live copy. There was really a live copy of the check. So That's how I knew it had not been cashed. So anyway, again, you would just put uncashed check and what is the amount of the check. In this case, we also have an uncashed Social Security check that came to them. And what is the amount of the Social Security check? Your last line item would be, there are some annuities or investment funds that pay out dividends, whether it's quarter, year, whatever it is. In this, and then there's two different ways. There's either a payout of the dividends, or they'll do what's called a reinvestment of those dividends, where they'll automatically not pay you or not issue a check, but they'll just reinvest it and buy more stock for this same stock company. So you could have either or. In this case, they had dividends that come to them in a check form, which means their portfolio really never went up. So if they've got interest or anything like this, in this person's case, they were paid out that instead of reinvesting this 352 into the stock and growing their stock fund. That's not well, that is advised now, but it's kind of not, and we'll go into that later when doing the other accounting part. Okay, so at this point, let's look at what do we have here now. So I've completed this. This is my responsibility. This is attachment 1. I'm done now. So I have all my totals. I've got all my descriptions. And what do I have? What is my total? I will go down to the bottom of the form, and at the bottom of the form, it will say total cash assets. Okay, this is my total. See this total I'm circling right here? This total. This total is very important for several reasons. This tells the court, 1, how much cash I'm responsible for. And we'll get into, there's a few things the courts will then do. They'll go, okay, she's got 57,000 in cash. Does she have a bond that covers that 57? Because if your bond at the beginning that you were required to get was only $20,000. Now this is going to be a test, not a test question, but a question for you guys. I've got a bond for $20,000, right? And we'll go back to the front page because I'll ask this again. But I've got a bond of $20,000, but I have cash of $57,000. What do you think the court's going to say to me? Come on, somebody tell me. Okay, the court's going to tell me, guess what? Your bond isn't enough. You need to go back in and increase your bond to $60,000 or so that your bond covers every dollar that you're able to spend. Because I will tell you, and it may not happen, and I hope it doesn't happen with any of you, but somehow, some way, almost every single one of my cases, cash runs away. I swear to you, I've never, ever, ever seen so much cash just run. I don't know where it runs to. I wish it would run to my house or run somewhere towards me, but it runs the opposite direction. So many of my cases that I have been working on lately, cash disappears, and I don't know how to explain it. I'll ask the conservator or the guardian, okay, well, where did it go? Oh, I don't know. Well, it went somewhere because cash just doesn't float in the air. So again, if you have a bond that covers all of this, then even if it should disappear, the bond will replace the cash up to the dollar amount it started, and the bond company will come after you. We don't have to worry about it. But as far as the court's concerned, you're covered. So let's go back to, this is our total of all the items we've listed as far as that we have cash. Again, that total might be 0 if there's no cash. If the person just had no cash on them, it might be 0. It might be 200. It might be a very small number, and it could be very large. So This number is very important because you're going to take this number and you're going to carry forward it to our inventory and appraisal line 1. Do you see this number right here? It's the exact number, and I'll let you look at 57,844. And let's go back to this sheet right here, which we just completed, 57,844. So again, you'll take this number and you'll carry forward it to this form. So that means on this day, I'm responsible for this amount of money. Again, anything should disappear on the 9th of March, you're responsible for it, whether you did it or you didn't. Because you reported, you had this much, you're responsible for it. Okay, now it may not have disappeared and ran. It may be for an actual expense, but we'll get into how do you record what has happened the day after or the day of your appointment, but was happened or given or your responsibility. Because say for instance, I go in and I find out what all my cash is, and then I also find out the PG&E is going to be turned off and the water is going to be turned off and things like that. And it's really urgent. I must make sure that nothing gets turned off the day I'm appointed. So I'm on the phone calling PG&E and I'm calling everybody and they're going, okay, we need a $500 payment today or we're shutting off your power. I'm using the Conservators' money and I'm going to pay that bill for them to make sure it doesn't get turned off. So even on my day of appointment, I could have expenses, but I will report those expenses on the accounting sheet. So that's completely different. Again, for this purpose, we're only recording what am I starting with. Okay, any questions, hon? Anybody have any questions I missed or anything that I can't really see the chat. I'm gonna move it. So okay, doesn't look like we have any questions, so I'll go on. Okay, so line 2, we get down now to line 2 and it'll say attachment 2. But look at the words, total appraisal by referee. So what happens is when you're issued your letters from the court, at the very, very bottom, and not on this form, but I'll show you where you would find it. But at the very bottom, right before the judge signs the order, which his signature will be over here on the order form, he will put or stamp a name and a phone number and sometimes an address of a probate referee that the court has assigned. You're not responsible for running around trying to find a probate referee. No, they will provide the name and phone number of the probate referee, and you must use that person. So what I would do is I would complete this form and then I'd find out who my probate referee is, and we'll go through what do you need to send them and all of that. So please make sure where it says total appraisal by referee, you're not a referee. So you're not completing that. But we're going to go to attachment number 2 and show you what you must complete. So I will go to attachment number 2 right now. And it looks like this. But yours is going to be blank. Okay, again, what will I do? I will put the name of the conservatee up top and I will put the case number. Same thing. This will repeat on every single form you ever have to turn in. You will always have to have this header up here. Okay, so inventory and appraisal number 2 that you do some completing of this, but not much. You tell the probate referee every single item of, now we're going to get into non-cash. Let me say that again, non-cash. So we are going to list many examples here of what some non-cash items are. Again, you may have none. And in this case, you would just not even need your probate referee. If you have any type of non-cash, you will need a probate referee, because that's not your responsibility to value the non-cash. Again, your cash, the bank values it, right? Your non-cash, a probate referee values. So what does that mean? You're not responsible for valuing anything. You are not an appraiser. You're not one who knows the value. And even if you do, again, it's not your responsibility, and you are not allowed to give value to anything, because your value or your opinion may be different than the beneficiaries or the heirs of that person's opinion. So let's say, for instance, you had this extremely old, rare car, and you go, wow, I've been to so many car auctions and shops and things like that. That car's got to be worth $100,000, right? Because you've been to auctions, you've seen them, you love old cars, and that's your thing. So you say it's $100,000, but an heir or somebody who may be inheriting it at a different time ago, are you kidding me? That's worth $1 million. That thing's so old, and it's got this, that, and the other. So what happens? You technically, by valuing it only $100,000, could be responsible for the difference to the heirs of the difference in value. You don't want that. So please make sure that you do not value anything. That's not your job. That's not your responsibility. Okay, so as an example on the attachment number 2, what I would list for the probate referee would be the real property. And in this case, the city of Newport Beach, I'm saying County of Orange, State of California, and I'm giving them as much description as I know about this conservative's property. Okay. Again, you see, I gave no value whatsoever. I am only going to be giving what is the property address and as much information as I can. Typically, I take this information off of a deed because I am able to run deeds and gather this information. But you could also get a little bit of this information off a property tax statement or something like that. But I try and give as much information as possible. Okay, in a second example, we have a vacation home. In this, we've listed it's a vacation home. It's in Palm Springs, County of Riverside, State of California. And again, I've given another description. You'll see again here, I have absolutely no value whatsoever. It's not my job to value this. Okay, I only provide the information of what the property is. In the next line item, we'll have household furniture. Typically, household furniture is not given a huge value unless you have a conservative that may have grandfather clocks or a lot of old antique furniture or things of that nature. You must be a little bit more specific than just saying household furniture if that's the case. If the probate referee looks at what's called just household furniture and furnishings, he's probably not going to give a very high value, because most of the time, even though to us our furnishings may be worth $1 million, to the everyday average person, it's not worth $100. But, we love our stuff, so we give a higher value to it. Anyway, you're not going to value any of the properties. So the household furnishings, and you would just leave blank here, and this is what all you would put. If there are grandfather clocks or old antique hutches, or let's say gun racks or something like that, that has a lot more value, I would put it as a separate line item so that the probate referee can give a separate value for it. Okay. So in this case, if we had an old car that or an antique car or something like that, you would list that vehicle, the year, make, model, how much, if you know, has been updated of it. Is it in good condition? If you feel it's in average condition, is it just in pristine condition? You would indicate that here and just help the probate referee. Okay, so right now we're going to get down to someone's earlier questions. Well, what do I do about they have stocks, bonds, mutual funds, anything like that? So you find out that you go into the conservative home and you find out that that person has an investment portfolio, and you may not know how many shares they have because it's hard to tell. You don't know how to look at an investment portfolio or not. So you can't determine if there are 10 shares, a million shares, or you just don't even know this information. What I would do if that was the case is I would call the mutual fund, speak with somebody there, and have them tell you on the day of your appointment, somebody needs to mute their mic, or I'll just mute it for them. Anyway, they will need to tell you how many shares that you have in that mutual fund, and you don't need to ask them what the value of those funds are. That's not your job. That's the probate referee's job. So you would just put how many shares that they have in what mutual fund, and then let the probate referee do his job looking up the value. Okay. Now, in this case, I also know that they have 7 $100 US savings bonds. And you may or may not know when they were issued. Savings bonds, usually they came in a certificate, the older ones. I haven't seen really any new savings bonds, but they came in a little, almost looking like a check certificate. They would tell you when they were issued and stuff like that. So that is common. Now, in this case, I have also listed, which I find funny, and I do this all the time. I have listed, ooh, I'm so sorry, my page jumped. And where was I? I was back here. That I've listed a diamond wedding ring, okay? Some people used to ask, or some people say, why is that important? Okay, so you have a conservative. And I'm just going to give you this example. And for some of us, let me start off by saying, me one, I'm not a diamond wedding ring really type of person. They've just been nothing fancy to me. So I myself have a very hard time telling the difference between a 2 carat and a 5 carat. Although to me, I think a 5 carat would look much bigger than a 2, right? Anybody could figure that part out, but I wouldn't have any idea looking at somebody's wedding ring, whether it's 2 carats, 5 carats, or if it's even real for that matter. But so it's really important to maybe ask or see if you can find out and or indicate by taking a picture of it. I always like to take pictures of things like this because I can prove what I had. There are many times, and I will tell you many, many, many times that you go in and you see the conservatee and they're wearing a wedding ring, and it's of, let's say, a small, a very small wedding ring, okay? And that conservatee has family members, children who live in, let's say, I'll use Hawaii or New York or somewhere, and they haven't seen their mom in quite some time, and let's say the mom's a conservatee. They haven't seen the mom in quite some time, but they knew at one time mom had a 5 carat wedding ring because she wore it all the time, and who cannot see a 5-carat wedding ring, right? But when you came in and became a conservator, mom was wearing a really small ring because maybe she was tired of how heavy the 5-carat ring was. So you never even saw there was a 5-carat one. You would indicate there is only maybe a 1-carat wedding ring that you've seen. More than likely, once you turn this in, because you need to give copies to everybody who is a beneficiary or a potential heir, they will look at this and go, oh, heck no. This person took mom's 5-carat wedding ring and replaced it with their 1-carat because they wanted to take it. Believe it or not, don't laugh. Nobody can laugh because it's happened so many times. You could be responsible for that difference between the 5-carat one that they say they know she had and the 1-carat you've now reported. Again, I take a picture, whether it's her hand, I just ask for a picture of her hand. I show what she's wearing. You can definitely tell the difference, or take a picture of the ring itself, and then you just know there was nothing more. Because a lot of times, boy, it seems like beneficiaries and heirs always know what their parents had, but the new person coming in may report something different. And actually, the beneficiaries and the heirs only have a certain time frame to contest what you've reported that they had. So say, for instance, I give this list and I report to everybody, this is what I find, right? 2 years later or so, a beneficiary, whether it's a son, a grandson, a friend, a church that said she was going to donate to everything to them, they'll say, oh, no. She told me she had 10 houses and 5 rings and 20 savings bonds. What the heck is all of this? Your chance to contest it ended long ago. So if they don't contest it within a certain time frame, and this is approved by the court, there's no contesting after the fact. So this is all I had. This is all I started with. It's been approved by the court, and this is all I'm responsible for. And don't worry about what the other beneficiaries may say to you at a later date. But people are very, let's say most people, I'm not gonna, don't think of it as like, oh my gosh, they're greedy or something like that. No, most people just want the right answer. They're not trying to tell you you stole or you're doing something wrong. They just want to make sure it is right. So don't get your feelings hurt if you list on here it's a 2-carat ring, and then later somebody goes, oh my God, she has no idea what she's talking about. It really was a 5-carat and blah, blah, blah. Okay, show me where, show me a picture that you have of her wearing a 5, just take it as they just want to verify what you have said of their moms or their loved ones is the right information. They're not accusing you of trying to be a thief right off the bat. Again, all they want to know is the right information. And once you prove to them or show them it's the correct information, you probably will never hear from them again. But okay, so let's move on. So again, you've listed all of the non-cash assets and you've given no value to them whatsoever, okay? None. You're not supposed to. So we're gonna slide down and there is a total line. But again, it's gonna be 0 because you're not gonna value this. Your probate referee is. Let's go back to the form. So here you will have 0 value. I need to talk faster because my time is running up. Anyway, so attachment 2 is going to be left 0 and you have a total down here. You're going to leave this right now because you're not going to put a total here. The probate referee is. Okay, any questions real quick? Okay, I'm going to continue to move on. So, excuse me. Next part of the form is going to be the declaration by you. And that declaration is, what do you mean I got to give a declaration? Well, all you're saying is you have provided to the best of your knowledge on attachments 1 and 2. We just went through them. 1 is your cash, 2 is your non-cash. So attachments 1, attachments 2 are true statements of all, unless you were doing a partial. Remember when I was telling you, you think, oh my God, there might be a whole lot of other stuff. I can't find it in time. You would just say a portion. You're trying to admit you just don't know everything yet. But most of the time you would state it's an all, and it's truly and honestly been appraised to the best of your knowledge. And again, you're only responsible for attachment 1. What is attachment 1? Cash. Cash, 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 cash. Okay? Now, remember when I explained that there's a possibility that you have no non-cash assets. They just didn't have any. They don't have a house. They don't have mutual funds. They don't have anything like that. If that's the case, you would mark this no probate referee is required because I have no non-cash assets. Okay? We have non-cash. So, or you can mark by order of the court and give a date. Property tax certificates. This will not be for guardianships or conservatorships. So you don't have to worry about it. This is only if the person's passed away. Would you need to worry about marking one of these? Now, we're going to go down to, you're going to put your name right here. But you will not sign this yet, and you will not date it. Why? Because you're going to send this form and your 2 attachments to a probate referee. Now, don't sign this before the probate referee returns your documents to you, because then they can add or subtract or cross out or do anything, and you've already signed it, so you're responsible for it. So don't sign this until it comes back from the probate referee and they have filled out these 2 lines right here. Then you can put your name, sign it, date it, and this information is correct by you. Okay, we're going to go down to the important thing, which I was stating a little bit earlier, the statement of the bond. Okay, there are 3 different situations here. You either have the bond waived because you're doing an estate, and in the trust or the will, it states no bonds required, or there's no cash. So if there's no cash, a bond wouldn't be required. You would mark this box. If a bond was required, a lot of times the court will, to give you your letters or to appoint you, they will require a minimum bond of $20,000 because they don't know how much cash there is. You have no clue how much cash there is. So they'll do a minimum bond of $20,000 just to get you started. Okay. So I'm going to give you this. We would mark this box and we would put $20,000 here. Now we have 2 boxes here. I have a bond of $20,000, and I'm going to ask you guys to respond. I have a bond of $20,000. Okay. I again have cash of $57,000. Which of these 2 boxes would I mark?
Insufficient?
Correct. And that is because your $20,000 bond does not cover $57,000, it only covers 20. So $37,000 could just disappear and there's no bond. What do you think is going to happen if you mark this box insufficient?
The judge will require to, for you to get another bond or
Correct.
to
They'll
have more money.
require just for you to increase it, hun. You wouldn't get another bond, but you would just increase the one you have.
Okay.
So then you would call the bond company and you'd say, I need to increase this to at least $60,000. And they'll go, okay. And they'll be happy to do it because that means more money for them.
Okay.
Or if you're doing a guardianship, a lot of times, if a minor is under the age of 18, they can't have cash, what they will do is you will mark this box, and the money that's up here in this $57,000 that you've stated in cash is in a blocked account, which a blocked account means you can have control of it, and you can withdraw funds from it, but only with a court order. So you really have to obtain a court order of why you want that money out, and then turn that court order over to the bank, and the bank will determine whether it's real, and it'll take days, and it'll have to go through their legal and blah, blah, blah. So if that's the case, you would mark a blocked account. Now, I won't ask the questions because I'll try and hurry and go through this. But if you have money in blocked accounts, which means you can't touch it without a court order, you can imagine you don't have to have a bond for that because you can't control it. There's no way you can access it. There's no way you can spend the money from it. There's no way anything can happen. So you wouldn't need a bond. Okay, going down again. It would be dated, you would print your name and you would sign it. Again, I'm telling you, do not sign this until you get it back from the probate referee. In this case, this person has an attorney, so the attorney would sign here. But if you're not working for an attorney and you're just completing it on your own, you would put your name here and you would sign it. Okay, we're now going to page 2. We're almost done on the inventory and appraisal. Again, you'll repeat the titles. This person's the conservatee. There'll be a name. This is the part that will be completed by your probate referee. Not only will he look at attachment number 2 and give a value. Okay, we're down. Oh, sorry, wrong attachment. Attachment number 2, he will put values in here. Most of the time they're handwritten. Sometimes they'll take the form and put them typed, and they will put a total down here. They will then put the total here, and they will add these 2 up and put a total here. Once you get this back from the probate referee, then you know you can sign it. You can review that his total on attachment 2 is the same number he put here. You added these up. These all equal. You're good to go. The probate referee will also provide what is his fee or commission to do this, to value this property. And any expenses like travel expenses, bridge toll, parking, what did he have to go through? All of his expenses he had to go through to value this. Now, typically I'd say a probate referee's fees, they're based on a percentage, I think, of what the total amount is that they value, but each one has a different value. And I've seen them as low as, let's say, like 500, and I've seen them as high as maybe 1,500. And then you would be responsible for paying that bill. Not you yourself. You would pay it out of the conservatee's fee. Out of the conservatee's money. Okay, so that probate referee will date, they'll print their name, they'll sign it, and again, they will return both forms. They will return this front form. They will return page 2, completed and signed. They will return your inventory and appraisal attachment number 1, which they have not touched, they've just looked at. And they will return the attachment number 2 with the values, a value at the bottom, and that same number you would verify has come over to the form. Again, they will return this to you, and it is your responsibility to file it with the court. You will be given a court date as soon as you file it with the court. And it'll be very important for you to, of course, always keep a copy of everything you do. But I'm going to tell you how important it's going to be that you watch this total here, because these here are how you're going to start your accounting. Okay, that's it for me. I'm going to push this over to Rex, who will do the accounting portion, and then I will be coming back to you because there is a third, what's called a petition, and that's the part I'll be coming back and showing you. So I'm going to hand you off to Rex and disappear for a little bit, but I'll be back. Thank you, guys.
When do you want to come back on?
When I do the
I don't know
petition,
how much time do you?
I'll watch it.
Okay, did you cover how they get the referee? Okay. Well, good morning. I'm Rex Crandell, and I'll be covering some of the things that happen during a period of time. So Tamara has gone over the beginning inventory and appraisal is at one point in time. And then at the end of a time period, your first 90 days, well, that's when you have to do your inventory and appraisal. But at the end of 1 year, you have to turn in the accounting. So you have time within the transactions have to be summarized and reported. And that's what we're going to be covering here. I want to get to the page. There's one form for court accounting that is absolutely pivotal. And that form is called a GC 400 sum. And this is what it is. So if you're familiar with business accounting, it's similar to an income statement, but people confuse court accounting with small business accounting or rental property accounting. It has nothing to do with any of that. It's strictly a creature of the California Probate Code. And you really can't use it directly for tax returns because tax rules are different. And I mean, a lot of it you can, but in California, it doesn't do anything simple. This is my probate code for California. So if you need something, you can look that up. But before I get into the details of this form, I do want to show you some information that will help you understand what the situation is. So this is called summary of account, standard and simplified account. It's required for probate, guardianships, and conservatorships. And if you turn in your accounting to the court for approval, which is a good idea, this format is also required, although the particular form is not. So you get the form numbers in the lower left. Judicial Council of California is like the board of directors for California courts and the California Supreme Court. And the form numbers, GC 400, guardianship and conservatorship, 400 sum, which means summary. And if your accounting does not have a summary like this, you aren't even close to being doing a court accounting. It's just not even close. So the other thing I want to point out in the lower right, if sometimes you're going through these forms and you have a question, does it mean I turn left here or turn right, or what do they want? Here is a reference for your use. Probate Code section 1060 is the starting for what California requires in the court accounting. And this next line is the California Rules of Court, which is also available online. So you can refer to those code sections if you want to look at more of the details, and Tamara gives me a bad time about the code section saying nobody wants to look at that. Well, some people do. And I just pointed out it's there if it is of interest to you. So what I'm going to be doing is first, I want to cover the summary sheet, which is the most important form in the accounting. And then we're going to get into the detailed schedules. And the way that the accounting for court accounting works is it's kind of like a Ferris wheel, like the London Eye, where every sub-schedule goes right back into the center. And that's what this form does. And it's a summary, and it, for judges and others that receive court accountings, they can get a lot of information about what is going on in the will, trust, estate, or guardianship, or trust. So this says we're doing the first accounting, which when you get your letters, it will be first. Tamara mentioned that the first 90 days you have to turn your inventory and appraisal in. The end of the first year, this accounting will be due, and it'll be your first one. And this doesn't really make sense, but it says it's an interim, so it's a current account. And then the date, the opening date of your first accounting is the date the judge signed your letters. Or if you became a trustee, it's the date you were appointed and accepted the responsibility to be a trustee. And then you go to 365 days later, and that's the end of the first accounting. You never go through more than 1 year. They're always kept separate. And this form, this example shows it's for a conservatorship. So let's say a senior who perhaps has Alzheimer's or in a coma or something. And then it talks about a guardianship. But as it said on the bottom of the form, you can use it for probate, or you're required to use it for probate also, guardianship and conservatorships. And if you are doing a court accounting for a trust, you would list the name of the trust here. And of course, your case number. Then we get into charges and credits. Now, there's a footnote that says enter a 0 for all categories of charges and credits that have no entries. And what they want you to do that for is that if you leave it blank, they don't know if you forgot it, or there is something, or you didn't get to it. But when you put a 0 in, that is an affirmative statement that the court wants. So in terms of the terminology, a lot of times courts use arcane language, you know, like old Britain with the wigs and stuff like that. And this is no different in my view. They picked the worst possible words to try to explain what they mean here. And if you have taken accounting classes, you more than likely learned about debits and credits. And I can tell you point blank, debits and credits don't do a thing for court accounting. In fact, it's the opposite. In regular accounting, double entry, expenses are debits and income are credits. So don't even try to cross-reference, it doesn't work. Okay, so what the term is, first of all, charges. And the way I like to look at the word charges is this is the responsibility that the fiduciary, the guardian, conservator, trustee, that's what they're responsible for. So you're charged with that responsibility until you discharge that responsibility through the disbursements part below. And one of the unique things about being a trustee or fiduciary is that if anything's missing, you got to pay for it out of your own pocket. It's immediate limited liability. So it's different than an LLC or corporation. Anything that goes wrong is usually the trustee's responsible for that. So charges for responsibility, and these two lines here, Tamara went through how they were derived. Line 1A, you just went through the form that you use for the cash assets. And there's another form that I'll show you. It's duplicate but required. And the line 1B, non-cash assets, that was the total given to you by the probate referee. And then you need to learn the word carry value, because it's different than in other contexts. In federal income tax, we have a concept called basis. So let's say I bought an apartment building for 8 million, and then I remodeled it and put another million in it. And so now my cost basis is 9 million, but then you depreciate it and your basis goes down. You don't need to remember that, it's just an example. What they're saying with carry value, and the reason it's so important, is the assets that were appraised, that value sticks during your entire time accounting for this entity. So it doesn't matter if it's 1 year, 5 years, or 20 years. The carry value, which is your burden of responsibility that you're carrying, is going to be the same all the way until the property is sold. So we have the total of those two numbers. Okay. So we go down through the line items. We got additional property received, receipts, gains, and then other charges. Now, this is inverse logic, because when I think I'm getting charged something, that sounds like an expense. But no, in the inverted world of law, these are other income items. And then there's the net income from a trade or business during the period of account. And fortunately, let's say you had a gymnasium and you had a physical fitness business and it was part of the trust. Fortunately, the trustee is not responsible for doing the books and having all of that business transaction detail come through this fiduciary accounting. The trustee or the guardian conservator, all they need to do is get the net income from the gym's bookkeeper or accountant, and then that net number is what is entered for this particular line item. So it's a great time saver if that's a circumstance. And so we're going to end up, after we're going to end up having to total this, the total amount of charges, or another way to say it is available. And this additional property received during period of account, this is a bit tricky, because sometimes when a fiduciary takes over the finances or assets of another person, they didn't know, but all of a sudden they found some more assets. I mean, I've heard of people finding, $100,000 of bonds, somebody hid in the box in the garage and things like that. The tendency would be to try to put it on your beginning inventory and appraisal, but you can't, because you've already committed to that. So it would be received during the period, and then it causes your carry value to increase. Okay, so we're going to talk about just regular receipts, rental income, different types of things, pensions, gain on sale. We'll get into the details of that. Then credits, I would like to use the word disbursements. That seems to be more common English in my view. But we have disbursements during the account period, Schedule C, losses on sales, which means you sold something for below the carry value. Now, distributions to conservatee, ward, or beneficiary, those go to reduce the available resources. And then other credits, other types of disbursements. And we're on the small business issue again. And if the gymnasium, let's say our example, ran at a loss, then the accountant's report would just show the net income there. And then we look at the assets at the end of the account period. We'll look at all the detail forms. And what we have to do is, at the end of this account, the line 14, total of credits, must equal line 7, the total charges. And if it does not, you're not done yet. And the courts are really picky. In income tax, we round off to the nearest dollar, and the IRS doesn't want to know the pennies. In the courts, they're pretty much anal. They're not going to let go of the pennies, because in regular business accounting, you know, we kind of joked around it when I went through accounting school, is, oh, if it's a quarter off, just tape it on the page and leave it alone. You know, it's good enough, but not in court accounting. So everything has to balance, or you're absolutely not done yet. Okay, so disbursements. And as we started out with the sheets that Tamara had gone over, beginning inventory and appraisal type items and cash, now we have the same drill at the end. We have the list of cash on a form, the non-cash assets using that same carry value to get the total assets on hand at the end of the account period. So these line items all are represented by a splinter of different schedules that we'll look at that add up to that number. They're all a summary. And I don't know, it seems like a lot of people attending today don't have their video camera on, and I thought that's a little bit better. See who's in the class here. So if you're not sitting around in your underwear, maybe you could turn your video cam on. But if you are sitting around in your underwear, don't do that, please. Okay. So minor request. Okay. I just got scolded. Uh-oh. Now, this form, it's a duplicate to what we started before. And it's set up here that it's not starting in our second account. That's not actually true. So you have, it's just a duplicate is what it ends up being. So that inventory and appraisals set of forms, redundancy, the court still wants this cash on hand at the beginning of the period, and they have separate forms that are required at the end of the accounting period. Another thing I wanted to point out as we go through, so it makes it easier to communicate, is I went and put numbers on the bottom of the page in the lower left so that I could reference a certain page number. When there's a question asked, we can find the page number. What the normal thing is people will look at the upper right for the page number. That's not it. That's the name of the form. So That's just for reference purposes. So no big deal. You just have to duplicate the number that you came up with for the beginning cash on your inventory and appraisal. And then the other item, the non-cash at the beginning of the account, needs to be entered again, duplicate in my view. And one thing about the non-cash assets that you had appraised, more than likely you'll have item numbers in your list of assets. And it's suggested that you keep those item numbers throughout the entire court accounting, multiple years, that you still only have one line item for that particular asset. Say line 5 was the, I don't know, the timeshare or something. And it makes it easier for people looking at your work to see that it's done right. And if an asset is sold, so you sold asset number 6, which was a rental house, just leave that 6 out and don't try to fill it in. So what? There's one number missing from your sequence. It's easier to keep that same number. Okay. The carry value is what was given to you at the beginning of period from the probate referee. So that has to be listed. On your first accounting at the end of the first year, you do not put this number in. Take that back. This is still beginning. I'm going to correct my statement, start over. You're doing your first accounting, but you have to have beginning numbers. You're using your inventory and appraisal, and the probate referee helped out on the non-cash to give you values. A fiduciary is not allowed to estimate values on their own. Now, in the beginning inventory and appraisal, this column here, estimated market value, that was the whole purpose of the probate referee that was assigned to you when you filed your papers. So the first beginning accounting does not have estimated market values, but at the end of the first year, you will need to put in estimated market values, because carry value never changes. Market value might change all the time. And in this case, since we're talking about beginning a period, it's the same. And if we had the page at the end of the period, you need to get an estimated market value. And it's not difficult, nor you don't have to worry about getting a wrong answer, because it's no harm, no foul. What people do normally with real property is they'll look on Zillow or Trulia or some of the other realtor.com and just get an estimated value and plunk it in. Another purpose of this estimated value is sometimes fiduciaries and conservators, trustees invest in risky investments, which they're not allowed to do. A risky investment might be a new startup technology firm. Well, the chance of losing your money is very high. So it would show that the market value is way lower, and maybe the investment policy of the trustee is inappropriate, and then get removed for that or get sanctioned from the court. Okay, so this particular form is a summary form, and I call this Rex's favorite form, because we're going to go into the detailed schedules, but this is a summary before you get to the GC 400 sum in order to collect the data. So if there were 14 pages on Schedule A, the Schedule A doesn't do what you would normally think is accumulate the numbers and then just one number comes because I'll show you, we don't add them up cumulative. So on Schedule A, excuse me, there's different subject matter, whether it's A2, A4, so rents are the form A4, dividends are form 400A1. And so this I like to do for summary. It just seems to make more sense to me to summarize it before you get to the grand total that moves forward to the GC 400 sum. And there again, receipts and disbursements. Well, this particular form used normal English, but receipts and disbursements make sense. But of course, this one says optional, do not file with your accounting. So I don't think they're going to shoot you if you do. So that's very handy to use. And all of the forms are available from the Judicial Council, and they're all available online, so you don't have to sort around. Some of the courts give standard packets of forms, but part of the problem with the court accounting is that there's 48 different types of schedules, so you do not need them all. Nobody does. Just the ones that mirror the kind of assets that you're working with. So we're starting out with dividends. So we list, if you have 4 brokerage accounts, list the one brokerage account, and then each of the dividends all the way down for that brokerage account, and then the next brokerage account list all the transactions. Now, it's completely prohibited, although efficient, to, like, say I got 47,000 of dividends last year or something like that. Unfortunately, in court accounting, you cannot do that. You cannot use a subtotal or a total. You have to list every darn dividend. And it's a bit tedious, but you just take them off the statements from the broker that you're going to have to turn into the court anyway. And there's one thing that's fairly frequent that will drive you nuts doing court accounting, and that is when you have a big stock portfolio and you have a dividend reinvestment program. For example, you get a dividend on your stock for, I don't know, Google stock that you own, and then your dividend comes in and you've told the broker, don't give me cash, reinvest it. Well, that's called a dividend reinvestment program. I abbreviate it DRIP, the DRIP program. And the problem with it for you doing court accounting is each of the dividends have to be listed here, but you don't have cash anymore. It was reinvested. So on each of those reinvestments, you have to show on another schedule that show you purchased 0.00073 of a share, and it just doubles your work on the tedious level of dividends. So if you have a DRIP program, I would strongly suggest that you tell the broker, no more reinvestment of dividends in stock. Take all the dividends and put them in a cash account, and I'll invest them myself every so often for the trust or conservatorship. So some of the details of the court accounting forms, it says here that we have a subtotal. So we're not done with dividends evidently, or income on the Schedule A, page A of 6. So yes, we're done with dividends, but there's 6 more page A's that we will be looking at. The next one is receipts of interest. And you list them by account, and last 4 digits of the account number is what we always do, and identify the institution. And if it's cash, fine. I guess all dividends would be considered cash, or interest earned on bonds and other things. And here again, we're on, it says subtotal, and we have a number here. So we're on the second Schedule A, which shows, no, that's the case number, Schedule A, but we're on the second one. And if you really want to mess up your work, accumulate numbers from the previous page. It's not supposed to happen that way. So each page just gets totaled on its own. And that's another reason for Rex's favorite form to summarize. And it tells the reader we have other Schedule A's coming, and we're only on 2 of 6. Then next one here is pensions annuities. And this would be, you know, independent or government pensions, but not Social Security, like CalPERS or those types of things, and just list each individual item. And if there's an expense that comes out of the pension money before it's deposited in the account, just enter the amount that you received. That's what you're responsible for. And we have another subtotal on A. We're on 3 of 6. So we're not done with the Schedule A's yet. Okay. The next one is for rents. So if there's a rental property or 2 or 3 of them, I would list the property where the rental is located, and I would describe what it is. Is it a single family residence? Is it a condo, commercial space? Is it a 100-unit apartment building or something else? Rents could also be non-real estate, you know, renting an airplane or a boat or something like that. If it's kind of like a passive activity, which is a tax term. But what they're talking about here, or wanting, is things that are passive rentals. Somebody just turns in a rent check. What you do not put here are businesses. So some of the things that you might think would be a rental property, if you had an Airbnb, short-term rental, well, for tax purposes and here, that's treated as a business, like a hotel, motel, spa, something like that. And it wouldn't go here. It would go in that summary page I showed you about business expenses, just entering in the net income from the business instead of all the details. And in terms of accounting, say you have a rental property, if you received a security deposit from a tenant, well, you're going to hold that for a long time, and technically you are going to give it back to the tenant when they move out and leave the tenant, the space clean and neat and no damage. So I would show the security deposit in receipts but it's really a liability you're going to have to pay back someday. So I would show it in the assets perhaps separately. Okay, so now we're subtotal again on A, page A. It's kind of tedious. I mean, they come up with the way that they designed the court accounting. I want to point out here something that's important. So on the GC 400, remember I pointed out that it was a required form or format. So on that one, adopted for mandatory use. Okay, so when you get into some of the others, it says approved for optional use. So what that means in practice is that you can use an Excel spreadsheet that has this same basic information and format. It is permissible. And although the Judicial Council says that the GC 400 sum is required, mandatory, I see accountings all the time being turned into the court where they're not using this particular form, but they've modeled the form in an Excel template, and that's what's turned in. But I think that's an accommodation that the probate examiners just do for the public. And the probate examiners, I remember Tamara told you about that, they give a tentative ruling before your hearing date. The probate referees are really helpful to you because what the probate referees do, it's like turning your papers into a teacher. So you're getting graded and they say, you left this form out, you left this form out, and they grade your paper. And if you don't fix it by the court hearing, that's what they're going to do, is make you go back and fix it. So you hurry up and do that. But it's a handy process to get because the probate examiners look at all the files before the judge sees it. So they summarize things. The judge may add items, but the probate referees are really good. And they're in the probate department in most superior courts. And the other thing that we've gotten permission to do in Contra Costa Superior Court is when the probate examiners are in their, what do you call, public hours, where they let people come in, you're filing papers and things, you can bring your court accounting, maybe you're not certain about the format or something else, and you can ask the probate examiners about, does this format look right? And they're very sensitized to the fact that you're only asking them about format because they don't want to get hooked in that they approved the accounting in total. So don't ask them about any, say outside of the numbers, I'm not asking about. I just want to know if the format or my Excel spreadsheets or other items are pretty close to what's required. And they will do that, and it's helpful. And it reduces the chance of rejection on the accounting, which happens a lot. This I wanted to point out. We had a probate referee in one of our classes, and she pointed this out immediately. If you'll recall, I said, you have to enter every transaction. Well, this example shows an error. You can't combine months every 2 months or 4 months. It's not permitted for court accounting. And there's two concepts. Well, one is I always insist on 6-digit dates because when you use 4-digit dates, month and date only, and I think that's how they teach kids in grade school, month and day only, it creates problems in the future. For example, I represented a client for an IRS tax audit, and he was a salesman and came in with a large stack of entertainment receipts, all of which had 4-digit dates: July 23rd, December 10th, October 3rd. And it became a problem because what, has this guy been collecting these for 5 years and he brings the same ones back every time he gets audited, or what? So make it a habit never to use 4-digit dates on any of your accounting, because 3, 4, 5 years from now, who's going to know what year did it relate to without guessing? Another concept in court accounting is to avoid is called netting. So netting means that, let's say you had rental income coming in and you paid a mortgage payment going back out, and there was a $10 cash flow, and you just net the $10. That's what we got. No can do. You cannot net anything in court accounting. You have to show them separate. Now, what is similar, but it sounds like it's the opposite, is when you have a vendor or government agency taking money that was supposed to be distributed and charging expenses before they distribute it, you can only account for what you got. So in that case, it's appropriate to net. In this case, there were Medicare Part B premiums that came out first. And that is appropriate. And it will eventually show up, that Medicare that was taken out, as at the end of the year on an IRS form 1099 SSA. And then it can be picked up and reported at that point. Okay, so we've got another subtotal, 5 of 6. So it looks like we got one of those left, another one. Receipts, other. So this would be everything else that didn't fit into a category. And don't really worry about, just do your best. Don't fret. I had one client from China that, or in our class, and he was just so worried about getting one line wrong. And, he was honest, and he just was so worried about the government. And they're not that picky. If you have it all there and you misunderstood or put it on the wrong schedule, they don't shoot you. But it's just do your best effort, and when in doubt, disclose what you did. So in this form, anything else, we had a state tax refund, insurance reimbursement. Here's a refund on Medicare. So all money coming in. Okay, so it says subtotal again, but we're on 6 of 6. So that means we're done with the series of Schedule A forms. Now, I'll give you the page number here in a second. This one. So if you go back to page 22, you can now summarize all those 6 forms, Schedule A's, into an appropriate category. And then run a total of all of the Schedule A items from your various schedules. And then when we back up to Schedule 20, is it 21 or is it 20? I have a problem with the page numbers. Yeah, it is 21, I think. The GC 400 sum. So you'll see that that number that we just looked at, the 43,181, was, well, we didn't, I guess you didn't have it filled out. It's supposed to be the one here. um, from all of the Schedule A's. So that kind of method goes through all of the forms, like there may be 4 Schedule Bs. And then if you add schedules, which you're certainly allowed to do, always use these given ones. But what I suggest you do if you're going to have a separate schedule, that you switch, instead of using letters, switch to giving them Schedule 1, Schedule 2, Schedule 3. And the reason why I'm saying that is when I first started using these forms, I was going to add a schedule and I first called it Schedule E. Well, down here hiding is a Schedule E. So that would have been a mistake. So, but every time you're going to add something like it, just give it a schedule number. Don't renumber things. Presumably, you could use these numbers. I just thought, say you're on distributions of the conservator, ward, or beneficiary, line 10, you could say Schedule 10. That makes sense. A lot of times in probate forms, we do it that way. I had talked to our probate examiners here in Contra Costa County, and I had asked her, because they handle a lot of probate accountings and other types, what are the common mistakes? And I thought that might be helpful. One of the common mistakes is your GC 400 sum doesn't balance. Don't even bother turning it in if it doesn't balance. You need to fix it. Another problem is that disbursements are not clearly labeled. So, example that are clearly labeled, East Bay Mud or PG&E, well, that's kind of obvious. But there are other times when the expense is not readily understandable. So let's say with your accounting, you bought a hot tub and had it installed. Okay, well, normally that sounds like it might be for the benefit of the fiduciary and not the ward or the beneficiary. But then you include in your accounting that this was recommended by the doctor, here's the recommendation, and it was put in because the ward or beneficiary has certain muscular problems. So explain how it benefits the ward. In the beginning, we mentioned that you can get this entire judicial counsel training online, and one of our local judges helped create it. But and then you have our class material to use as a reference. But I wanted to show you another reference source on court accounting. And another point is that California court accounting may not be exactly the same as Nevada, Arizona, New York, Florida. So if you're doing out of state, you need to get your state rules. But this book, Fiduciary Accounting Handbook, I'm trying to get it set up here. Okay, so this is put out by the Continuing Education of the Bar. And you can look up specific items. You have some unusual transaction and you want to know how to report it. You can buy this book and you can look it up. It's $205. And if you're doing extensive high dollar amount accountings, it'd be worth it. The CEB, if you're interested, is in Oakland, 800, phone number 800-232-3444, or Their website is ceb.com, continuing education of the bar. And I know one of the attorneys, well, two of them that helped write this book. One is Margaret Hand, and I've taken many court accounting classes from her. And the other is Don Edward Green, who was the judge here in Contra Costa for quite a long time. So if you need more reference material, that might be helpful. Does anyone have any questions? Is anybody awake? Hopefully. Okay, so we're going to move on to, we're going to go to the disbursements where the money disappears. No, we have one more income item. We had the miscellaneous income. Okay, now we have gains and loss, well, gains only, losses would go somewhere else. But you'd have to do this if you had stock sales. In this case, it was a real estate property, a house. And I'll just go through how they want it reported. You have to show the carry value of what you're getting rid of. And we're talking about, go back to your carry value that you had from before. It's page number 29. Okay. 30. Okay. You take your carry value, you list it. Sale date, and then the sale price is the gross sale price for that transaction. And then you report your gain. And that is the way you have to do sales of real property. But anyone who's worked in the real estate area knows that what you paid for it, for example, and what it sold for is not the real gain, because there may be 3 to 5% of closing costs, escrow fees, loan broker fees. And so this goes against all tax accounting, but that's what's required for court accounting. So you just do it. And then that item, whatever item it was on your inventory and appraisal, like say it was asset number 6, will disappear from your schedule of carry values. Let me see. Oh, when you're dealing with the escrows, we're going to get into the escrow costs in a bit, but always make sure you get what's called the final closing statement, because I have clients turning in closing statements and the heading says estimated closing statement. Well, I don't know if something's changed. So I have to have them get the final so that we know we're dealing with proper numbers. Okay, so still on the disbursements, we're on Schedule C at this point. We're looking for a residential cost. This is, in this example, a care facility. You know, the skilled nursing facilities are so expensive. This is 2012 rates. I mean, it's not uncommon to have to pay $5,000 a month for skilled nursing. We have one client that pays about $150,000 a year for nursing costs. Anyway, so same thing about subtotal 1 of 8 of the C series. And it is, this form is optional use. And then we get into other types of disbursements. This is your miscellaneous because it says general. So if they didn't fit in another category, you got a conservator fee, attorney fee. This is a reimburse for cost. It says reimbursement. A guardian, conservator, or executor cannot get paid at all, nor can an attorney be paid unless the court issues an order that they be paid. So don't make that mistake. It's not the case for trustees, but everything from the guardian, conservator, and the attorney representing them must end up getting a court order before that payment can be made. That's to protect the assets. So we've got a filing fee to report the accounting, copies of letters, court investigator, probate referee for valuing the assets, and then first year premium. So list the total on those, and anything else that's unusual. And list to see, well, premium on additional bond. Okay, so this is pretty straightforward, that it looks like it's for the benefit of the ward. And another thing that can be done, if you have something that you feel may draw questions, maybe something out of the ordinary, unique, there's, I frequently do, and it's appropriate to put a footnote, like, footnote 1, and then on another schedule on the bottom of the form, describe what it was, why you had to do it, and how it benefits the ward. And in this case, we've got just standard living expenses. And this, just whatever seems reasonable. One thing that it doesn't sound logical, but let's say the ward has a capability to work, even though they have a guardianship or conservatorship, and they earn money, that is not included in your court accounting for some reason. And if the ward or beneficiary there's in the trust owns property out of the state of California, it's not listed in your court accounting because the California court does not have jurisdiction. So in case you have those circumstances. Okay, so we're looking for medical type items at this point. We've got Dr. Zhivago, x-rays, medical, ambulance, just list all of those costs. Now, here's the other half of the real estate transaction. And on this one, we have the escrow costs. So we had the escrow fee. These are expenses. You just took them off the final closing statement. And what you would have here is what they call non-recurring closing costs. So these are items that were paid. They're non-recurring because they're only paid once on the sale. Other adjustments in an escrow that are what they call recurring closing costs, like insurance, interest paid, property taxes, those are recurring. So they're not treated as part of the sale. They're treated in the area of the other disbursements. And in the sale, they paid off a loan. Okay. Now, this one is just it's not a net number. They had furniture that the ward was never going to use again. It was sold off by a personal property broker, and their commission was the $500. So that's the amount of the expense or disbursement. And if you had furniture, which you should on an accounting, you just estimate it. And it doesn't have to be that accurate, but then it would have to show as a sale also to come off of your inventory and appraisal. Okay, so we're on Schedule C, 6 of 8. Now we have rental property expenses. I would show those separately. In other words, you have rental A, then all the expenses. Rental B, all the expenses. And what happens with somewhat regularity is somebody likes using spreadsheets like Excel, and they will take all the expenses and put them into columns across the page to show the expenses. And that might work wonderful for tax. It is completely unacceptable for court accounting. Number one, you cannot use any page in landscape mode. It sounds picky, but that's the rule. You cannot use spreadsheets or anything that runs off one page that goes on to another page. Cannot do it. Each page has to be in portrait mode and stand on its own with a total and a schedule number. So, you know, I've had people turn in accountings to the court, and the court just basically says none of this is even close to court accounting because they used tax accounting methods that, as you see, it's not included here. So they ended up having to redo it. And then the problem for a trustee or a fiduciary guardian is if they hire somebody that to do a court accounting, let's say they have to do a court accounting, and they hire a vendor that says they can do it, and then it turns out the vendor just horribly messes it up and not even close. And then the trustee or guardian has to go out and hire a second person to do it right. The court is not going to allow one disbursement to be paid twice. And the court will sanction the guardian, conservator, or trustee and make them pay for their vendor's screw up and not following proper court accounting procedures. And then the court would approve the vendor who did it properly. So that's a risk for guardians, conservators, and trustees, that you just can't assume that the person knows what they're doing, because oftentimes they don't. And the personal liability to the fiduciary is no fun. Okay, so we have other disbursements, tax repairs, paying IRS tax due, and we're on page 8 to 8 of Schedule C, so we would go to that summary page to accumulate all the Schedule Cs. Now we have another property sale. This one is sold at a loss. So we had a old car on our inventory and appraisal that had a carry value of $3,100. We only got $3,000, and there's a loss. So here they're saying it was item asset number 7 from the inventory and appraisal, which is good to cross-reference. Okay. Oh, there's a term here, standard and simplified accounts. It makes sense. Some people think that simplified accounts is what you want to do. It's not. We're only talking about standard. And the difference is simplified would be, it would end up looking like a check register with a little bit of income item and a couple expenses. And if there were 5 transactions, 8 transactions during the year, which can happen, simplified account may work well. But I would advise against using that system, and I don't teach it. Okay, so Schedule D, okay, so that was disbursement type items. Now we're on Schedule E, which starts in assets at the end of the account period. So that might be December 31, it might be the anniversary of when you received your letters, and you're listing the date. There again, just list the assets at that particular date. I would list the asset numbers, like from the inventory and appraisal, and then the non-cash at the end of the account period. Just list what it shows on the broker statement as of that particular date. And I know for probates and trust administration, sometimes people will have a large stock portfolio, investments, and you really have to have the value on the date of death, which ends up being your carry value. And what we do is we ask the client to talk to the broker and ask them to give us the value on that particular date. And it's fairly common. And then we bring that into our carry value from then on at that number of shares at that value. But the other thing you need to make sure that happens for your ward or beneficiary is have the stockbroker, if it is a death, the cost basis on the account goes up to market value with the broker. Just ask your broker about it. It's called step up basis. And if you don't get that into your broker statements on a decedent's estate, then somebody's going to have to pay too much tax in the future, capital gains. So basically we have carry value, estimated market value, Trulia, Zillow, some of those values are just guesstimate. And then we go back to, since we've gone through all the expenses, we go back to page 21 on the inventory, correction, GC 400 sum, and bring forward all our expenses, any other schedules we have. The two forms we just talked about were the cash, non-cash, and the balance that has to match. Another technique that I recommend that we learned in accounting school was always check your numbers when you're adding up a series of numbers. You're going down a column. And, you know, I learned it from adding machines, and you always check your tape. Well, most people aren't using adding machines anymore. But if you're adding on your cell phone or on a computer, it will show the numbers that you keyed in. And I recommend that you verify all the totals, because you will be amazed at how much time it takes to try to find an error in a big accounting. It's unbelievable. So, and you're stuck. You can't move ahead until you get that error worked out. So check your numbers as you use them. So we're back at the GC 400 sum. This is the pivotal form that's going to go on top of your account. And then you cannot turn an account in this way to the court. You have to file a petition. It's also called an account and a report and a request for attorney's fees or guardianship or conservator fees. So it's a court petition that goes on top of this, and put all of your bank statements in sequential order, the originals underneath the accounting in asset order. And I also recommend that fiduciaries, conservators, and trustees insist on the bank giving you images of the canceled checks. If there's ever a question about some transaction, it may be helpful to have an image of the check to verify what, that the signatures weren't, they did match, and the check was actually written to the vendor whose name was indicated on the accounting. So this would wrap up the numeric part, and I'm gonna find Tamara Brown to go through the petition report and the other filings, and she'll be right here.
Hello, everyone. I'm back. Okay, I've got to do some speedy talking because we're supposed to end at 12. I'll probably go a tiny bit longer, but I'm going to do some real quick talking and see if we can get through this. Okay, so I'm sorry, I have to find the form now where I start my part. It looks like this is odd. Sorry, hold on. I've got to scroll through.
I'll find it.
No, it's up here and
Yeah,
then it
that's-
goes at the end. I don't know. Okay, I found it. Sorry, guys. So the last part that we will be going through today is once you do your accounting, not only do you need to turn in the accounting, as Rex said, with bank statements, is you have to write up what's called a petition that states, okay, now you've turned this in. What do you want done with it? Is basically what this form does. I must tell you, this form must be on pleading paper, which pleading paper means there's lines on the side. You can look up pleading paper templates online. I know Microsoft Word has them. I had an attorney contact me, an attorney I've worked with for many years. So I'm used to him. And he was trying to do a pleading without me, which is, I always laugh, but sure. Okay, so he was trying to do a pleading and he wrote me and said, oh my God, I need some of your time. I need you to devote an hour or so. And I'm thinking, okay, what's wrong? And he said, I have pleading paper. I need to turn in a pleading, and the court states the pleading has to be in 12-point font. And I'm like, okay. And he said, but it says it has to match up the lines. So what he was trying to do is make sure that every line, so this attorney one that doesn't match up a line, he says the court won't accept it. I can't figure out how to get this on line 2 and make sure that every line matches. Or if you look at this one right here, it's in the middle of between 8 and 9 technically. And he's like, they're not going to accept my plea. And what am I going to do? I need this to match. I want you to spend an hour on the web finding pleading paper that matches the line item. And I love this attorney. So I laughed for a minute, and then I finally gave him a call and said, you will never find a pleading paper that will match every single line item. the courts will allow you to use this one. He's like, no, they won't. No, they won't. But so anyway, don't worry about it. Please use the pleading paper. Does not have to match each line, and you'll be good. So, okay, let's start it off. So this header that you see up here, again, this is if we were using an attorney. And you'll remember when I said at the first talk of my, when I started the inventory and appraisal, this would be really your name. You would not put the state bar number. You will not put you're an attorney at law unless you are. You will put your address, your city and state. You will put your phone number and fax if you have one, and your email address. Then you will put, you will not put you're an attorney for anybody. You will put your name only and your title. And then you'll just skip down maybe 3 lines, and you will put Superior Court of California and county. If you'll remember, when I first started the inventory and appraisal, your county will be not be Orange, it will be Contra Costa. That's the example we kind of used. But you will use whatever county you're going to submit this to. Okay, you'll come down a few lines, and you'll see it states conservatorship for the person and estate. I don't know if Rex went through that with you, but when you receive your letters, there are 2 different designations. They are truly different. You can either be the conservator of a person, which means that you just must take care of the person and all the personal matters. Take the person to doctor's appointment, take them to the dentist, take them, make sure their care, make sure if you find or you see any bruises on them that they look possibly like bruises they could have, you know, done themselves and not anybody else do. So it just means you're responsible for that person only. And or you can just be a conservator of the estate, which a lot of times if the person can kind of take care of themselves, but they just get a little bit confused on how to write checks or pay bills or things of that nature. Or if you think about somebody who could be, okay, I'm gonna use a little bit of the older generation where you have a husband and wife, and maybe the husband has always paid the bills and taken care of everything, and the wife was the housewife who only did, you know, the chores, the cooking, the grocery shopping, but she really didn't have much to do with the finances, and she doesn't know how to pay bills because she's never had to do them. Husband always did them, and he's no longer able or no longer here to be able to pay the bills. She just may not know how. Then you could get a conservatorship of the estate. The estate means the money. So it's of the person, of the state, or you can be the conservator of the person and the estate, which means you're in charge of both. So just make sure that, especially when you applied for the conservatorship, you knew the difference, and or if you really should be conservator of both and you only are the conservator of the person, you would have to go back and get your letters to be of the person and the estate. So you would not really be completing this accounting if you were a conservator of the person, only really of the estate. Anyway, let's go on. So here we have Jeannie Lowry, who for her, she's also known as Jeannie Gray, and she's the conservatee. We move over to this side where you always put the case number. Remember, in all of our forms, we have the header that the conservatee is up here and the case number is along here. You would give that same case number right down here. The title of your petition is typically going to be the first account, the second account, whatever account it is, you will have a petition with every account you turn in. Basically, you're stating this is the first account, and it's a report of the conservator, you, and a petition for its settlement, for approval of what you did during the accounting period, and for compensation. I will tell you that this is one only tiny little drawback that I have with doing probate. I myself love probate. I love conservatorships. I love estates. I love helping the elderly. I love anything to do with the elderly or minors who may need a guardianship. That's my job, and I'll be continuing to do it till I no longer can. And the only thing about it is, please realize you do not get paid until the court tells you that you can be paid. That goes for the conservator and goes for the attorney. In some cases, if you're a conservator for your mom or somebody like that, you may be okay with never getting paid. You just don't need, you just feel it's your responsibility as a daughter to take care of mom. And in other cases, when maybe you don't have that close of a relationship with the person or whatever, you may say, "Oh, I want fees." It's a lot of work. It's rewarding, but it can just be a lot of work for some who already have a family and another job and other things to do. So we'll go through how you determine that and how you figure out what the compensation and stuff is. But in this case, you're reporting to the court what you are going to ask for further down in this petition, okay? And the reason why you ask for its settlement is because, again, once the judge approves this accounting, approves your expenses, approves that what you've spent for little things, and sees that they're reasonable, there's no beneficiary that can come after you for misappropriation of funds. So okay, so you will get a hearing date when you turn in the accounting. You will get a hearing date that will tell you when the hearing is, or you will get that hearing ahead of time. So you will put that information here with the time of the hearing, the department. Most of the time, what I like to do, I'll tell you, is even though you know what judge you have, I know for Contra Costa we have 2 different judges, but for Alameda County, which I do a lot of, there's many, and for San Francisco, there's many. A lot of times, you may think that a certain judge is going to hear your case, and maybe that day of your hearing, the judge is out ill or has a personal matter he's attending to, so a commissioner or somebody else will hear the case. So I typically like to leave this part blank, and they'll fill it in. The judge will fill, commissioner, whoever's signing this for you, will fill that in. But if you want to know who the judge is, if you put a judge there and that person is not there that day, or somebody else is hearing, the other thing they'll do is they'll strike through and handwrite their name and sign it up top if they're not the judge that day. Anyway, okay, let's go on. So what are we going to state? What type of information are we going to put in this petition? Basically, you're going to say you yourself are the petitioner. So you are coming before this court. So you, the petitioner. Hereinafter, I'm going to call myself the conservator. So you just don't have to keep repeating your name. So as the conservator of the estate, now see how this says it's only the conservator of the state in this case, but also states otherwise after. Anyway, of Jeannie Lowry, the conservatee, presents for settlement and allowance this verified first account of my acts, basically. So you're respectfully stating what happened during the year. Please keep in mind, you're giving a judge, you could only imagine how many cases he sees, hears, has to review in one single day. Even though you may have had this big impact on him the last time you were at court, imagine a year, 2 years later, he is not going to remember. So what you're doing with this petition is you're giving a real quick snapshot for him so that he, when he opens the file, doesn't have to look back through, okay, when were her letters given? You know, it's just a real quick, easy snapshot for them. So the first thing you would state is your appointment. So you state me, I was appointed to Jeannie on this day. I got my letters from the court this day. Because you're not going to receive them the same. In most cases, you won't receive them the same time. It used to be when you could kind of go into the court. Some courts, what they would do is if you had court that day and you wanted your letters, they'd say you can pick them up later from the examiners, or come back a little later, and they'd have this little Dropbox thing that you could also pick that up that day, and then the dates would be the same. But most of the time, especially now with COVID, and we hear most cases via Zoom, you might be appointed one day and your letters would be mailed to you and issued on a different day. So that's the two different days and why you have a different this is kind of hearing date, and this is actually when your letters were issued by the judge. So at all times since the appointment, you have been acting as the conservator. You're never allowed to give it off or state, I'm so sorry, I couldn't handle it because maybe I was having a kidney stone surgery or something, and I let my husband or brother or somebody else act as a conservator during that time. No, you're never allowed to do that. If you cannot act during a certain period, if it's a short period, just nobody acts. If you need a long period of time because of some other medical issue, then you do a whole nother thing, which would be kind of like I would do an ex parte, notifying the judge that you are no longer, or you cannot for a time period, and I would state what that time period is, act as a conservator. We'd replace it, meaning the whoever's replacing has to be bondable, has to be known, would have to prove quite a bit to the court. So a lot of times I'll do a professional fiduciary for just a short time period because we can instantly get them in without a normal person has to go through getting approved in a bond and stuff like that. So anyway, there are steps to take if you cannot fulfill your duties for a short time period, but then want it back once you become better able. Okay, so you're telling the judge, this is my inventory and appraisal, and it was filed on what day? So you tell them when it was filed, and it showed a value of the estate. Now remember, you have cash and you have it non-cash. So this is the total of both. And more than likely, the examiners have already verified this total is the same total as on your front page of your inventory and appraisal. Okay, so we'd go down to number 2 or 3, the account period. It's easy for you or easier if you can just tell them, please, what the account period is so they don't have to go back and forth looking. So you would report your account period. Now, if you'll notice this March 8th, I'm going to slide up a little bit where that date comes from. That date comes from the hearing where you were approved and appointed as the conservator. It does not come as the date of the letters. Again, it's a date that the judge confirmed your appointment. So I'm going to slide down again. So you will state you will need to do a year's time period because remember, your inventory and appraisal is just one day. It's the day you were appointed as the conservator. Your accounting goes the day after and through the next year. Okay, here you will state you learn for charges and credits by Mr. Crandell. The conservator is chargeable and is entitled to the credits that they've already reported on the summaries, so on and so forth. You can use this wording or use your own. I find depending on my situation, I may add, or a lot of times I'll use the same wording. If the judge does not like it, they will cross out whatever they don't like and add what they do like. And trust me, even after doing this for many years, I still get some of my petitions or orders back, and almost every line item the judge has crossed out and put his own words. And I'm like, wow, that's a pretty piece of paper. It's kind of embarrassing though, because I've done this a little while and still to this day, it's like, okay, wow. I was that far off track. No, they have their own reasons, their specifics, and they really will write what they want, no matter what you have on here. So unless you're completely missing that, what I typically see, okay, is from a judge is if you're missing the data, which means you just left it out mistakenly or on purposely, they will make you correct it yourself. But if you put something up here like, say for instance, I would ask my attorneys once in a while, ask for fees for extraordinary services, and I'll put conservator shall pay attorney for extraordinary services. And if the judge doesn't prove that, he'll just cross it out. So if I put something in there the judge doesn't like, or a judge wants a little bit different wording, they will cross it out and write their own. But if I left something out, they'll make me redo the whole thing. So that's kind of how it goes. Okay, we'll get down to authorized investments. Again, we were talking about what did you do during the accounting period. So you must follow exactly what you did on your accounting. So during the accounting period, all cash has been invested and maintained in an interest-bearing account. I'm not sure if Rex went over this, but you as the conservator are responsible that if the minute you get your letters or your court date and you're assigned your letters, well, I'd say the minute you get your letters, because you need that piece of paper called the letters to go to the bank to get anything changed anyway. Please make sure you ask that banker, is this an interest-bearing account? And it has to be at least moderate. It cannot be aggressive, and it can't be doing nothing. Here's a little situation. Again, I don't know, I'm sorry if I'm repeating myself, but there was a case long ago. It wasn't with this firm here, but one I've known of, and we use it as an example. So the conservator did not put this person's money in an interest-bearing account, and it went for a couple of years. And the beneficiaries, when they finally got their accounting, because maybe the conservator was late turning in an accounting, when they finally got their accounting, they noticed, why isn't there any interest? Now we're talking the beneficiary. So the beneficiary says, wait a minute, how come there's been no interest? There's $500,000 in the account sitting and absolutely no interest. That's crazy weird, right? So they contested it, made a complaint, filed something with the court, and believe it or not, the conservator was responsible for paying the interest from the date of her appointment to the date that this beneficiary received their money. They had to pay what that interest would have been because they did not put the money in an interest-bearing account. So the conservator had to come up out of their own funds for not putting or keeping the money in a interest-bearing account and lost the beneficiaries. Well, they considered the conservator lost them money, and so they sued the conservator for the interest that they lost from them not doing that. So please be careful and just make sure that it's in an interest-bearing account. But you will report here during the account period, all cash has been invested and maintained in an interest-bearing account or in an investment authorized by law. Okay, we're going to move down to a statement of liabilities. Incorporated in this petition is the statement of liabilities, and there are no taxes due but unpaid and no outstanding judgment. So basically you're just telling the judge there's nothing that he needs to quickly act on. Like, say for instance, there's a judgment from Franchise Tax Board that they're going to lien the account or something like that. If you haven't taken care of that, you still better tell the judge that you haven't taken care of it and you need to do it, because they will be right on that. And there was this other case that I had. You have to be careful. If you got something from Franchise Tax Board that says there is a balance due from prior years, even though you were not a conservator at that time, if what you first need to do is verify it's accurate, see if you need to get a transcription from Franchise Tax Board to see if it's really payable and hasn't been paid. If it's just because they haven't filed taxes, you may have to run through and go file taxes for them. But I had another case where the conservator kind of knew but didn't do anything about this person owed Franchise Tax Board, and it was for many years. And Franchise Tax Board at the end charged like $3,000 or $4,000 of interest and late fees for the taxes not being paid that were owed. And the conservator ended up having to pay those late fees, because if they would have just paid the balance due to Franchise Tax Board when they found out, there wouldn't have been those late fees. So guess what? You're going to be paying them. So unless you have a lot of cash that you just wish to float around and pay on other people's bills, please make sure you take care of Franchise Tax Board, IRS, property taxes, the big stuff that will come after you. Okay, in the example on the accounting of Rex's, there was a sale of an automobile. So you will state, yep, I sold the automobile, they can't drive anymore. On the inventory and appraisal, you would have saw that, as this is only an example because you did not see it because we didn't put it on our attachment 2 in our example, but you will see on attachment 2, line number 7, and there was a loss on the sale. So originally the probate referee, again, because this is a non-cash item, you do not value it, only the probate referee can. So the probate referee gave $5,000 for the car. You did your best to sell it, but there was a lot of scratches and maybe the interior was ripped a little, and just there was for things. You attempted to sell it for the price the probate referee gave, but you just couldn't. I am not saying, where I had another case just recently, a couple of days ago, I had somebody come to me and they said, well, right before the decedent passed away, they told me that they wanted to keep the house in the family. So they wanted me to, because the beneficiaries were young, they wanted her to sell it for under fair market value, so that grandkids or somebody could really afford to buy the house and have their own house, and that is their luxury. Well, so they had a trust. I glanced through it and I said, you have like I'd say 30 some people that were nonprofit organizations like Boys and Girls Club that were to inherit, she gave away as part of a beneficiary 2% to the Boys and Girls Club. Now, if you could only imagine 2%, let's say we had a loss on this vehicle. It was a vehicle and your son needed a car, but he could only afford $3,500 and it was valued at $5,000. Obviously, you see that there's a loss there, but you can't do that. Just because your son needs it, he can only afford $3,500. You think it's worth $3,500. I wouldn't even try that scenario, because really the beneficiaries on this estate will say, no, the car was worth $5,000. You didn't have a right to undersell it for cheaper. So you're responsible for it. But if you really, really do try your best to sell it for what the probate examiner said it's worth, and you just can't get that, don't be scared to still sell it. I mean, really sell it for, and then you just report on here, I took a loss, and I took a loss, and why. We'll get into a little bit of that later. So anyway, you also sold the furniture and fish. Oh, goodness, I'm having a hard time talking this afternoon. Furniture and furnishings, the conservator, because you knew that they were not going back to their house. Maybe they were going into a nursing home, maybe going into a care facility, maybe going into your house. You just really didn't need the furniture. And believe it or not, if you know that conservator is never going back to their house, like you just know that nothing will get them well enough to be able to take care of themselves, because now they're at a little bit higher of a, they have to prove to a doctor a little bit higher standards to be able to be incapacitated and then all of a sudden become just fine and capacitated. So if you don't think they're ever going back to their house, storing furniture and storage for no reason at an expense to the conservator is not in your best wishes. If you know they're not going home, you know they're not going to be able to use this furniture or furnishings again. First, I talk to the beneficiaries and see if any of them want it, but if not, you are allowed to sell it. So in this case, the conservator sold the furniture and furnishings in the home. In this case, you have a home, this is the vacation home. This was not the permanent residence. So this was the vacation home. You sold the vacation home, you sold the furnishings. So you're stating what you did. Okay, I'm going to slide down. Now we have, okay, again, let me remind you that even though I have these numbers and they're numbered this way, you may not sell a car, you may not sell a vacation house, you may not have these line items. Do not put them in if you don't have them. So you may go from the top here, sorry if I'm making you dizzy, you may go to the top here, which might be number, let's go back, after 6, your number 7 could be this one. I mean, it don't put it in unless you had the example, but we're just giving you how you would use wordings if you had this case. So also in this, we're going to state that we sold property. So we sold the vacation home and the date of the sale. Okay, so now remember that we started off, if you remember in our example, we started off with $57,000 of cash. And I asked you if you had a bond for 20, would you have enough to cover the cash? You said no, appropriately. Now, in this case, you sold a vacation home. Guess what happened? Your cash went from here to here. And more than likely, if you had a bond that only covered that $57,000, you sold a vacation home and now you have $557,000, your bond is, your bond is not going to be enough. So at that point, you would just say, I know my bond is not enough. I know I need to increase the bond. Okay, I will get right on it. And the court will probably have you verify you've increased your bond. Okay, another this is a number 11 is something that I would mark, circle, highlight, identify. Please make sure you have. If you do not have this on your petition, it will be bumped out right away. This is a must. You must state if you hired anybody that was a family relation to you or the conservator during this account period. I'll give you a real quick an example. We needed landscaping done because the outside of the house, they've had landscaper for years. The landscaper was sick all of a sudden and was sick for some time, and the yard needed to be landscaped. I can go out and hire another landscaper, but I really would be cautious if that landscaper charges more money than my regular landscaper. That's one. But two, say for instance, I have a son and I go, oh my gosh, he's here from college and he needs work to do, and I'm tired of him sitting around the house doing nothing and complaining. He has no money. We don't have a gardener. So son, I'll pay you $150 because I just need somebody and I don't want to deal with it. I'll pay you $150 to go mow the lawn for grandma. And he says, oh, geez, yes, okay. That'll take me an hour. Definitely, I'll do that. But your regular landscaper, you regularly only pay $40 or $50 to mow that lawn. Ooh. That is trouble. Not only when did you give it to your son, but you allowed extra money to go to your son because one, it was your son, and two, you just didn't want to deal with going out and calling a bunch of other landscapers and taking time to get a new one in. Absolute no. One, you'll be charged back for that $150. And I'm not saying you can't hire a family member. Yes, you can hire a family member, but that family member cannot ever charge an hourly rate more than a regular person would. And typically the courts will look at very closely that family member should probably charge a little bit less because that's grandma. I mean, you don't take advantage of grandma or you're a family member. So, you really shouldn't charge as much. So be very careful, but you must state if there was, whether there was or not, you must always state whether there was somebody you hired that was related to you or known to you in any way, really. Okay, so now we're getting down to the conservator's compensation. This is always the fun part. Remember I stated when we were doing the inventory and appraisal, you have the option whether you want to decide on compensation. A lot of times, if you look at an advanced healthcare directive or a will or anything like that that was already written, where they put who they would want as their conservator prior to really getting the conservatorship, they may state that the conservator, if I do get a conservator, should be paid a reasonable salary. Everybody in the world goes, okay, what's reasonable? What's reasonable to me might not be reasonable to the court, might not be reasonable to grandma. What's reasonable, right? So it's silly wording. But do keep in mind that there is local court rules. I always tell everybody, and I glance every once in a while, but I know kind of pretty much when the local court rules are updated, but local court rules, and it'll be something like, I'm gonna lift a piece of paper. You probably won't be able to see it fully, but it'll give you an idea. the local court rules, let's see if I can slide it over, will actually tell you what the acceptable fees are for what you're doing. So for instance, and I want to say, well, mine expired on January 1. It was local court rule 7.450. I think now it's local court rule 7.50 or 7.50 something. But I'll find that out before I teach the next class. But it gives the rates that you're able to charge. So it gives attorney rates. It gives a fiduciary rate. So if you are a fiduciary, your rates are much higher than the normal average person. A non-fiduciary rate, I believe that it didn't change, and I believe I've looked this up and verified. The non-fiduciary rate is $50 an hour. That's what I would consider the majority of you all, especially if you're doing this pro per. So in this case, you have stated that you have spent over 150 hours providing services to the conservatee, who is, in this case, the mom. You visit the care facilities once a week. You made sure she's receiving proper care. All her needs seem to be met. You've marshaled the assets. You've paid all her bills promptly. You've managed the estate frugally, which means you're not out buying her steak and lobster every single day just because you wanted steak and lobster, so you want what she can't eat or something like that. I know it sounds ridiculous, but you wouldn't believe what we see coming through the courts a lot. Conservator arranged for the sale of the house and the automobile, which she can no longer drive, listed the house, met with the realtors, had to travel to Palm Springs, which dang, I would love this case. I'd love to do that. Sure, I'll go. Anyway, sold the vacation home to raise money for her care, rented out her other home for a monthly fee. You don't necessarily have to do that. The only thing that I would consider for all of you is if you moved mom into your house and you know she's not going back, leaving her house vacant a year, not appropriate. You're still paying the property taxes, the PG&E, the water, the garbage, and nobody's living there. Why? Either rent it or if you know absolutely 100% sure she cannot go back to that house, then you would sell the house and not keep the expense. Unless you have like a trust or something which states the house goes to a beneficiary, then you cannot sell it. You would do deeds and other things, but that's more of, should I get an attorney to do that? Anyway, the conservator has not paid themselves any compensation. Now remember, I said the fee is $50, 50 times 150. You guys would all calculate that up in your head to be what, 727,250. Anyway, in this case, the conservator has already said, no, I don't want that hourly rate. I'll just take $500. So this person has decided to tell the judge, $500 is reasonable for me. For the time I miss work and attended court hearings and stuff like that. So I'm okay with that. In this case, this person had an attorney, so the attorney hasn't been paid either. And the attorney, so you would state, I hired this attorney, he was counsel. Attorneys can only charge a certain rate also. So $3,500 is reasonable compensation for that attorney. Now we're getting down to, did the conservative have?
Wait, I have a question.
Go ahead.
So, if I'm paying out of my own pocket right now, the attorney fees for this, but the estate has been requested to repay the attorney's compensation, do you have to wait a year to recompensate yourself for the monies that you paid your attorney with?
Yes, ma'am.
Oh, Okay,
Typically attorneys, or typically for people who know better ahead of time, know until the attorneys, they'll know if it's a conservatorship or something like that, that they don't get paid until the court grants them or grants you permission to pay them. And we know, I'm saying I know that I don't get paid until we go to court and settle the matter. Now, sometimes with yours, because it's a year, it would be more like a yearly thing that that it needs to be turned in. I have some cases that have gone on 2 and 3 years that, yeah, I still am waiting for funds, but we just can't close because of this, that, or the other. So yeah, you cannot reimburse yourself. You cannot pay yourself. You cannot pay an attorney. Nope, nothing until this is approved and the judge gives you permission to pay. Otherwise, if you pay ahead of time, there's a possibility judge will make you put it back, and
okay, okay, all right,
don't do that.
okay.
Sorry.
That's okay.
That's why typically, like I say, instead of using your own funds because you're like, well, shoot, I couldn't afford it either. Usually most attorneys who work in the field know they're not going to get paid until they, until you get an order from the court. And if the attorney will not accept that or state, no, you're going to pay me now or ahead of time, then find another person who would, hon.
Oh, okay, all right, thank you.
Because we do know that going, I mean, this is our field. We know what the what rules we have to follow. And so, yeah, like I say, me taking advantage of you doesn't help things at all. Like, I know I'm not supposed to be paid until it's approved. And so asking for you ahead, asking you to pay it out of your own pocket is a little inconsiderate of me, but I can't state what other law firms and stuff do. And I just know here we don't do that.
I wish I would have known that. Thank you.
That's okay. Okay, I'm gonna keep moving down. State hospital, you state whether the conservatee was an inpatient at a state hospital because of the fact that if there's like Medicare, Medi-Cal, there could be some type of chargebacks, or there could be something where they want funds from the estate. So you need to just tell the courts whether they're an estate facility or not. Okay, now one thing it's not required, but I always like to do it, would be you telling where the conservatee is living. So in this case, they have indicated that the conservatee is now living at a convalescent hospital. And where? What's the address of that convalescent hospital? I can tell you it's not for the purpose of the judge going to visit that conservatee. That will never happen. But it's just nice that you've told the court where this person is. It's a nice, and remember the beneficiaries all get a copy of this, so they're being told where she is also. Okay, account statements, I promise I'm almost done. Sorry guys, I know I'm 20 minutes off. But some of this is really important. If you guys need to leave, please feel free to do so. Otherwise, you can stick with me and I'll just try to go through quickly. Okay, account statements. Remember when I stated in the inventory and appraisal, it's going to be very important that you go to the bank right away and tell them that you need paper copy statements. If, for instance, you have forgot to do that and you get to the end of your accounting and you go, oh Lord, I'm in trouble. I don't have any statements that I could turn in. I only have the ones I printed off online off the internet. You must walk into the bank. You must ask the bank to print you certified copies. The bank will do so, maybe for a little fee, but the bank will do so. They will print you certified copies, and that is good enough to turn into the court. Here is why you will see number 17, account statements submitted to the court with, and you can decide whether you want to attach to them or not. From what I hear, more so, which this didn't used to be the case kind of back in the day, that you can submit bank statements, but not attach them to this petition, and then they don't become a part of the public record. What happens is the court only looks at the bank statements, verifies the account numbers, and just does what they need to do to verify your numbers, kind of look right, look good, you're all this, and then they do shred them. Yes, it was, sorry, Rex is shaking his head no, but if you do not attach them, they do not become part of the public record, that anybody could order a copy of those bank statements. But you must turn them in. That does not mean you cannot turn them in. You must turn them in. And again, don't forget to redact the account numbers. And I said the account numbers only. Just be careful, because sometimes, like on Wells Fargo, you can see that the checking will be up here, and then you'll read through the transactions, and then maybe on page 2, halfway down the page, you'll see the savings account numbers. And so it'll keep continuing on. Make sure you redact in all the places that the account number would appear. And again, I myself leave the last 4 digits. You can leave 6. You can leave 5, whatever you wish to leave, but be consistent with it, so the judge understands or sees what you're doing. That's all.
I have one more question.
Yes, hon.
So when I go to the grocery store, for example, and I buy, some food, I'm using the card. Do I have to keep the paper receipt from Safeway too? Or
Oh,
not?
absolutely, I would. Can you imagine if you didn't? And like, I know we had another case where I was cracking up. It was another case, but the beneficiary was kind of questioning some of the expenses done by more a trustee. So a tiny bit different situation. But here we had, I want to say the mom was 93, and she tiniest little thing you could ever imagine. She would maybe only weighed about, 80 pounds. She was just this little tiny thing. And I said, wow, as I'm looking through the accounting done, there was Safeway. And it was about every 3 or 4 days, $200 or more of expenses at Safeway. And just me, I'm thinking, okay, we have this tiny woman who isn't 4 foot tall. She weighs 80 pounds. I can guarantee you, like my boys, I've got 4 high school boys. Yes, we go through about $200 of groceries every 4 or 5 days. That's normal, but not somebody who is in her 90s, tiny little thing who might weigh 80 pounds. So in that case, I have the opportunity to say, oh, no, you're not buying. Something's going on there, or you're buying your groceries with hers and things like that. When you have a receipt, Hannes, whether it's Safeway, Trader Joe's, whatever it is, you're proving, if anybody questions, yes, she wanted $100 bottles of wine, and so I bought 1 bottle every 4 days, and but that's her favorite. She's been doing this. She's been drinking that same bottle for 10 years. That, at least you have a receipt. If somebody says or contests what you're doing, you have something to show what it is that you're doing. So what I like to do is just keep like an envelope or a file folder, maybe in a drawer or something. And every time you go to the store, just drop that receipt in that file folder and keep it just in case. Okay, hon, I'm going to keep going. Here we have told the judge that there have been capital changes. That means that either the interest rate has increased or decreased. On a few of these, the example I would give, or I have a lot to give, You guys couldn't imagine. So we've been doing this talk all day. Rex is sitting here eating his big old lunch, really literally across a short table from me, and I'm starving. So I'm sorry, I'm so distracted. Anyway, okay, so capital changes in this case, or how this would be used for me is a lot of times I can tell you with as soon as COVID hit in March of the last year, you know, the stock market went and crashed all over the place. Many accounts will state there was a huge crash to the stock market. And if you really had that kind of change, make sure that you state, you know, and why. Believe it or not, the judges all know why you would have had this change. Stop eating so loud in front of me, driving me, I'm starving. Anyway, sorry, I'm giving him a bad time. So there was a change in your stock market values. That's what that meant. Statement of estate liabilities. This one states that there is a promissory note still secured on the property. That could be if mom took a second note or an actually secured or took a loan against the property way before you became a conservator. You would still say the note's still in effect, and you're paying the balance. You would state what the balance is of that note on the day before. Again, this is one that's a little bit different, but this is the day before you got assigned, so that they know already she had a balance before you even came on. In this case, they state the note calls for payments of $2,500 and the interest rate on this note. I would tell her if it's at 5.25% right now, I would suggest, well, she can't really refi, but I would say, wow, that's too high. We can get mortgage, loans now for 2 something. But this is what you're stating in your petition. Special notice, real quickly, what does that mean? Anybody can go in for $40, and I'm not kidding, that's all it costs, $40. I can find out that you have a case in court. I can spend $40. I can fill out a form and state, I want to know every single thing that happens on this case, which means every time you turn in an accounting, every time you file a petition, every time you do anything with the court, you must send me a copy of it. I don't have to know the person. I don't have to know you. I don't have to know anything about anything. I could be bored and just want to file a special notice request. A lot of times I will tell you, you will get special notice requests if there is especially a trust or an estate and FTB is owed some money, or IRS is owed some money. Or I also see them quite frequently on, believe it or not, beneficiaries who take inheritance advances, which means they know grandma passed away. They know that they're going to get an inheritance. They don't want to wait till this estate closes. So they'll take what's called an inheritance advance, and those things are ugly, 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 ugly. Typically, if you take an advance of $20,000, I see almost all the time that the people who give these advances also charge $20,000 for you just to get a $20,000 loan. So if you're willing to give up an extra $20,000 just to get it right now to go Christmas shopping, yeah, believe it or not, I have 3 cases going on right now that they did that, and it's insane. But they will file a request for special notice. Otherwise, and you'll get a copy of it in the mail. Otherwise, if no notice is ever filed, you would just put on here no request for special notice. So I'm at the very end. So what do you want? So the judge goes, okay, thank you for all this information. What do you want me to do now? Well, I want to pray that, and you always kind of use or request very nice words for the judge. But what you're gonna, this is what you're asking for and you're asking him to do. You're asking him to basically approve and settle the count and report. And once he approves and settles it, the statute of limitation for the beneficiaries comes to a nice screeching halt. Anyway, that the acts that I did are approved, meaning I sold the car, but we'll get down to those little specific things. So in this case, that the sale of the automobile is approved, even though I may not have got the full value, I tried my best. The sale of the furniture is approved. So here we get to the fun part. That upon the settlement of the account, I'm authorized and directed to pay myself the sum of $500, because remember, that's all I asked for. I said I did 150 hours and I only wanted to be paid $500. And then also I asked for up above that the attorney be paid $3,500. He's not been paid yet, so can I do it now? We get down here, the last thing I always add is, you know what, Your Honor, you make any other call you feel is proper and just. If you anything else I've left out, but you want to approve on your own, or feel free to do so. Always give them that option. And then you will date it and you will sign it. That's you. Down here, if you do have an attorney working with you, you wouldn't be preparing this form anyway. They would, more than likely. They will attach a line and fill out their own signature, and then you will submit this to the court. One last, I haven't gotten there yet. One last thing that needs to be done is a verification needs to be attached. A lot of times, you will see this is one of the #1 reasons that a petition is rejected, because there's no verification. And I can't think of the exact words. The probate examiners, account needs to be verified or something like that. It's something that you look at it and you go, okay, what do you want me to verify? I think of verified as totally a different thing than what this is. So when I first started doing that, I'm going, okay, do I need to verify the numbers are right? Do I need to verify the bank statements there? Me, the word verified was a totally different word. No, anytime you see an examiner state the account needs to be verified, or the petition needs to be verified, or something needs verified, or they may use the word verification, but I've never seen that they do. This is what they mean. They just mean you yourself have not completed this verification. If that is the case, all you would do is on your pleading paper, do this verification and turn it in, and that's all they want. And all it is stating that you are the conservator, person's the conservatee, the account was filed with all the schedules, it's true as far as you're concerned, the information to the best of your ability and your beliefs, it is true. It contains everything you know, and under penalty and perjury of the state of California, it is correct. You will date it. This completely left me. You will date it, and then you will sign as the conservator, and that will be your last page. So I am done. I wish to thank you all. I hope you enjoyed it. Again, you're free to take this class any other time. I'm sorry I went over, and I'll see you later. Thank you.
And I'll just wrap everything up here. Thank you, Tamara. If you have additional questions about the material or other aspects of the state's trust or tax, you can give us a call at 925-934-6320, or you could email us at rexcrandell@astound.net. And if you want this fancy proof of completion that you survived the court accounting in one piece, you could send us an email and we'll submit that to you so you can impress your friends that you completed the class. And so any other questions before we wrap it up? Okay, well, we'll see you next time. Thanks for attending. Bye.